19 rights, which the Constitution does not permit. And I target Section 19 because only the President is barred from holding public office, from seeking to hold a public office after removal from office. Not anybody else, not the public protector, not the Chapter 9 institutions heads, not judges.
Yes, but Mr. Masuku, I hear your submissions and your line of reasoning, but maybe we shouldn't stray far from what these proceedings are concerned about in this sense. The designation of Dr. Hlophe is to a structure that we've been talking about here, the JSC. And in that sense, the way I understand the attack, if we may call it that, by the applicants, is that he needed to be considered for suitability to that structure, and that it is not purely about him, and that the assembly needed to consider his suitability. And in considering, it seems to me, I'm just paraphrasing what has gone on, it seems to me the applicants are saying that the assembly just relied on what has been referred to as a convention or a practice they had applied in that designation. In other words, and this is why they are not querying his designation by his party. No problem about that. But they are saying what took place. Now, and you'll correct me if I'm wrong, to personalize it, so you're just attacking him as a person, and how far can it go? But it seems to me the attack was in relation to his designation. They are not attacking his designation or his nomination by the party. Therefore, it's not personal. That they leave alone and they understand. And that's how I've understood it. But if you're saying, you're just going for Dr. Hlophe, I understood you to be saying, no, you didn't do this right, according to the applicants. That's what not the Constitution asked you to do. You followed the convention instead of sitting down and considering this matter. So whether it was Dr. Hlophe or somebody else, you say, you must do it right. Because imagine a situation where they had sat down and looked at the law and so on and so forth, and shown that in a record. Maybe your arguments would be saying, no, don't touch this. This is a parliamentary decision. It was done correctly, not according to convention. It was considered all the rationality issues and so on. So I'm just mentioning that for your consideration.
Madam, thank you very much for the question, for the comment. Your Lordship starts with saying that I mustn't stray. And I've listened to your Lordship's what you put to me. And I'm still concerned about the comment that I mustn't stray, because I don't believe that I'm straying. I believe I've answered the question you've just raised. The question that you put to me is exactly what I'm suggesting. Is what should is an interpretation that we put on Section 17778. Firstly, there is no requirement that they are suggesting there should be a special procedure for former judges who are impeached. Secondly, I will not comment about the personal issues, because these papers, my lord, say a lot more about Hlophe in his personal capacity. What you're being asked there is to look at whether there was any attention paid to Dr. Hlophe's moral standing. They call him disgraced. National Assembly should have looked at the disgraced judge and asked itself, should we place a disgraced judge in the hands of the NP, in the hands of the JSC? So we have to be very fair in how we look at the arguments that are being presented, because the argument I am making is that there is no, for example, the procedure they've argued for would not apply to anybody else, because nobody else of the 6 people that are members of the National Assembly designated to serve in the JSC. No one else has been spoken about. We don't know who they are. You are only being asked about Dr. Hlophe, and that is why the focus has to be Dr. Hlophe. And that's not being personal. It's really we're really asking this court to look at this case for what it is. What the DA fails to achieve in the debates in Parliament, they brought it here. The same arguments they brought in Parliament are here. But they failed through the process of Parliament. So what they are asking as a remedy is that this court must then intervene and do what? Create an ad hoc committee. There was a proposal of an ad hoc committee. Have a special attention paid to, is he fit to be, and your lordship used the same word, is he suitable to be a member of the JSC? And my argument, and it was relevant, is that the only suitability requirement under Section 178 is membership of the National Assembly. There's no other. As it would be with reference to a judge president. The only suitability requirement is judge president. As it would be with the advocates. The only suitability requirement is advocate or attorney. And that's the argument I'm making. I'm not straying away from the case. I'll be very concerned if that was what the court was suggesting I am. I'm making strictly arguments that are relevant for the client I represent. Which is that you have to look at what the DA is asking you to do and Corruption Watch. They are asking you to tell the National Assembly how to do it. In fact, your lordship actually raised the relief that the Corruption Watch is asking for. They want the matter to be referred back to the National Assembly to take the decisions referred to in paragraph 2 and 3 about afresh, in accordance with the principles set out in this court's judgment. So essentially what the DA wants to do is to walk into the National Assembly carrying a judgment of this court, so that the proceedings of the National Assembly are guided by that court. And I have no difficulties with the guidance if the guidance was warranted. If there was an attack on some legitimate attack on how the National Assembly conducted itself. And the answer to your lordship was given by the speaker yesterday, who was very meticulous about what exactly happened. The day proposal was made, there was an objection. That objection resulted in a postponement. The matter came back again. There was a division, parties debated. And there's a transcript showing how parties debated the issue. They debated that precisely because the issue of his nomination had been, nomination by the party had been called into question by a party that has always been anti-Hlophe, which is the DA. So the point I'm making is that where does this logic take us? This logic of saying target somebody as they seek to do, go beyond the membership of the National Assembly. Go beyond that. That is a member of the National Assembly. Because that is not what the Constitution requires. The Constitution does not require us to go beyond the membership of the National Assembly.
Yes, so you are saying what is reflected in answered meets, for instance, the standard of rationality.
I'm concerned even about the use of word standard of rationality. I say yes, it does. But what it does is also reflects the debates that took place in Parliament over the suitability of Judge President Hlophe.
Yes, just wanted to confirm that.
Yes, the DA had a different view of it, as they always do. And the Corruption Watch now has a different view. In fact, I'm going to deal with the Corruption Watch's allegation that he should repent as a criteria, as another criteria for him to be considered for membership of the JSC. But so I'm saying, and this argument, my lord, dovetails with the argument I submitted yesterday, which there is no answer to. My learned friends have not answered in their papers. I mean, I know the DA says they are horrified by the argument that there are no consequences for a judge who has been removed from office, either for gross misconduct, incapacity, or incompetence. The consequence is only removal. There's nothing else. I know that they say there should be consequences. But what those consequences are, they don't say. And this is the reason why it's important to look at the nature of the impeachment process. Because we cannot suggest that the constitutional makers were not aware that at some point in our history, at some point in our constitutional development, there will be a need for Parliament to remove a judge. They were aware of that. But the constitutional makers made it clear that the only person who will suffer consequences for their removal from office is the president, not anybody else. So Dr. Hlophe walks out from the bench to the streets to campaign for his party in exercise of his rights of Section 19, and he now has free speech, freer than the judges that are serving, because he can say whatever he wants. If he's in Parliament, he's got parliamentary privilege, and he cannot be impugned for his speech. So we are seeking to amend the Constitution via the courts. They're asking for an order that essentially amends the Constitution. So in the order that they are seeking, or in the judgment that they are seeking, there will be something that says, we know that there are no constitutional consequences set out in the Constitution. There are no consequences for judges who are removed, or the public protector, or the chairperson of the Commission for the Human Rights. There are no consequences that are set out. Only the president suffers consequences as a result of removal from office. We know that. But actually, we would like more consequences to be added. We'd like an amendment, either in legislation, I don't know whether it would be the remuneration of judges, whatever that act, which is called the Judges Remuneration and Conditions of Employment Act, or some other act which must be amended so that it deals with what happens when a judge takes forced or a leave or leaves the office in different circumstances. One circumstance would be where he's removed by the National Assembly or the President in terms of the Constitution. Then the Act would say, in the event a judge is removed by the President in terms of Section 177, I think it's 2, then these are the consequences that follow. We don't have that. The Constitution was very clear and very, very, very precise. It made sure that the only consequence that a judge suffers is impeachment. And I did say yesterday that there is not a single person here who would not know the humiliation that Dr. Hlophe has endured over the 13 years or 14 years or whatever years that this case has been running. Everybody knows that. And so what the DA now wants, and the Corruption Watch, they now want a bit more, because they are not content with just the removal from office. Because the removal from office is intended to serve 165(4). You are removed from the office because you can no longer play. You are no longer. Your presence is no longer consistent with judicial independence. But how does that support the argument that is being made, which is that when the National Assembly designates people for the 6 people in the National Assembly, there ought to be attention paid to 165(4). From the evidence, we know that only Dr. Hlophe's suitability was debated by members of Parliament. There was a vote over his nomination, and the majority, using a convention of decision-making convention that is acceptable in terms of the Constitution, was adopted. The Corruption Watch, and in some extent the FUL, they looked at Judge President Hlophe's response to their founding affidavits. And they were, dare say, a little perturbed by what he had to say about their attitude. Dr. Hlophe says, I intend to use my new role in the legislature to promote judicial independence. No judge should ever be impeached because they had a conversation with another. That is twisted, deliberately twisted. Twisted to mean that he says he's going to promote the conduct for which he was impeached. It is deliberately twisted. It's a false rendition of what he says. All he has said in his affidavit under oath is that as I sit as a member of the legislature, having taken the oath of office of being a member of that house, of honorable people who represent the nation, I intend to use that position in order to advance judicial independence. What experience does Hlophe have? Let me start with the experience of impeachment. The experience of impeachment. If you want to look at how judges are impeached in South Africa, you would have to look at Judge President Hlophe's impeachment. You can't avoid it. You have to look at how he was impeached, and ask yourself, as a judge, this is the template for removal of judges. Here is how it happened. There was a complaint. It was processed through by the JSC in 2009. Members of the JSC in 2009 acquitted President Hlophe of gross misconduct. They looked at the same conduct that was looked at by the subsequent JSC, and they said, nah, it doesn't rise to the level of gross. Fair enough. They jump up and down, they say, no, you are referring to a decision of the JSC in which there was a division. If there's one thing that has to be clear to judges, is what is gross misconduct. There cannot be dissenting views about what gross misconduct is. Because a judge sitting there has to be certain that the conduct over which they are judged is precise. So we have the first JSC in 2009. Only there was, I think, a single, two dissenters out of the numbers that were in 2009. They said for the same conduct that he was convicted later, they said he was not guilty of misconduct. When the subsequent JSC took over, that JSC was not unanimous about whether his conduct was gross misconduct. And this is a body of lawyers referred to in the judgments as a body of lawyers who are left to decide what to do with a judge who's charged with gross misconduct. They also can't get it right in the sense that there's dissenting views on it. So Judge President Hlophe says, okay, fine, I mean, there's different views about what gross misconduct means. There may be a minority here. In the past, there was a majority. Now there's a minority. Let me see whether I can try my luck with the National Assembly itself. Because these are legislators. They can legislate and tell us exactly what the standard of gross misconduct is that should hold a judge accountable. He goes to the National Assembly, says, hey, I run an inquiry so that I can tell you my evidence and tell you why I think this is not misconduct. What does the National Assembly do? They say, no, we just want you to tell us about consequences. Tell us about sanction. They actually use the word sanction. Tell us, give us representations on the issue of sanction only. Because the issue of whether you're guilty of gross misconduct or not has been settled by the JSC. They consider themselves bound by that decision of the JSC. There's a debate about it. FUL was there. Well, that debate, we lose it. But nonetheless, we lose it in court, the full bench. Judge President says, President Hlophe appeals, lodges an application for leave to appeal. He's granted that leave to appeal. What does the state do? They withdraw funding for his legal representation. Because what then happens is that if he has to produce a record, he must produce a record that costs about 600,000. He doesn't have that money. What happens? The matter lapses. Because he cannot have the money to do that. Because the state, which had always been paying, decides no notice, no reasons given, they just keep quiet. He appeals, he writes letters, ends up litigating. The matter is pending in the High Court in Gauteng. The reason I am raising this, Honorable Justices, is because you have to be absolutely rigorously fair in how you assess this case in relation to what is presented as settled facts. There are no settled facts here. The impeachment, the lawfulness of the impeachment of Judge President Hlophe is pending. Is a matter that is still ongoing. He tried the Constitutional Court on a direct access basis. They told him no. Your matter involving whether or not the National Assembly violated the Constitution when they removed you doesn't belong here on an exclusive jurisdiction basis. Go back to the High Court. So I'm involved in the case. We've done the application. All it needs is signature, and it will be served in the High Court. So the presentation by my little friends for the DA, the Corruption Watch, and FUL wants the court to handle the case of whether Dr. Hlophe is suitable, assuming the court was going that direction, on the basis that this is a settled issue. It is not a settled issue. The court will still be asked to determine whether it accepts that a judge can be impeached in the way that we've just described. State withdraws funding. The National Assembly says we're not conducting an impeachment hearing other than on sanction. So essentially what the National Assembly says is that we're not going to exercise our role even at the level of being an oversight, at the role of oversight, whether or not your removal from the office complies with Section 165. It is consistent with the dignity of a judge, it's consistent with all the values that are set out in Section 165.4. We're not going to do that. That's the National Assembly that tells it. He challenges that. That's what he's challenging. He says a judge ought to be removed after the National Assembly has conducted a proper hearing on every aspect of the case. But that's a case you don't have to decide. All I'm submitting is that you should not be invited to treat these facts that are presented by the DA, the FUL, and the Corruption Watch as though they are settled. There are dissenting views about whether his conduct was in fact gross misconduct. Dissenting views. Forget about the National Assembly because they didn't even go that direction. They didn't even want to go the direction of inquiring through a proper hearing whether this was the legal standard that they've established for judges of gross misconduct. So it's the fact that there's still a split around whether the misconduct that is alleged is actually gross justified the National Assembly's intervention through a proper inquiry. That wasn't done. So we're back in the courts asking the courts to correct that issue. Justices, you'll know that through the impeachment process of Judge Hlophe, he had the right to approach the Constitutional Court, and he did. The Constitutional Court asked too many questions, one of which was, where do we get people to judge your case? Because half the court, 3/4 of the court is conflicted. We can't sit. We accept it's a constitutional issue of momentous importance because it implicates 165(4). We accept that. It's a constitutional issue, but we just don't have the quorum. What is the result of that? And bear in mind the constitutional consequences of a constitutional court refusing to hear a matter that should be heard by it in terms of the Constitution, and saying no, because we can't have a judges to hear the matter because they are conflicted in various ways. We are now going to accept, and this was an argument advanced by on behalf of the Honourable Justices of the Constitutional Court, that what should be accepted is the SCA judgment. So in the Dr. Hlophe cases, you'll find that although he raises legitimate constitutional questions and has a right to have those constitutional questions decided by the highest court of the land, he couldn't. Why? Because the court said there had no judges to hear the matter. And what the result of that is that a Supreme Court of Appeal, which is which does not have the last word on what the Constitution means, that's the judgment that is binding today. And we say you have to correct this kind of precedent. All I'm saying is the impeachment of President Hlophe, of Dr. Hlophe, is a painful chapter in our constitutional history. It's celebrated by others. It's not celebrated by many. Because the idea that this erudite, this man who's come from a jack to a king, from rags to riches, is simply removed with such disgrace. And according to the EFUL, the problem was that he came to according to Judge Krigler, he came to the bench too early, and power got to him. They insult him in the public domain. As a judge, he couldn't respond. They must try it now. He will respond. But as a judge, he maintained stony silence. They would insult him in all corners. I mean, we have sent it out in our affidavit to the Supreme Court, to the Constitutional Court, which was dismissed on the basis of constitutional. We're going to send it out again in the High Court. And the reason I'm raising this is for the court to understand that there are no barriers to the National Assembly, especially also given the differences on what constitutes gross misconduct, if that issue were to arise. Because there are, amongst lawyers, there are dissenting views on it. And the JSC's dissenting voice was even larger. It was 4 to 6, if I recall correctly. Mr. Katz dealt with the issue of composition. Why interdicting Judge President Hlophe would impact on the composition. I do not intend to deal with that. I merely support what he said, but point out the case, and I think he did refer to the cases, the Judicial Service Commission versus K-Bar, 2013, Volume 1, SA 170. And the relevant paragraph there that I would commend the court to is paragraph 27, which deals with the composition. If Judge President, if Dr. Hlophe is removed, the consequence is going to be that the matter is remitted back to the National Assembly. There are two ways to look at it. The MK essentially would have been put under warning not to renominate him as their nominee, because the court would have said so. The court would have said some things about it's necessary for the National Assembly to do a fitness test or a suitability test of Judge President Hlophe. That it's not sufficient that he is simply a member of the National Assembly. And so MK must then look around and say, Dr. Hlophe, hey, now in light of this judgment, what do we do? You are the person with over 20 years of experience, working with the judiciary, working as a judge president, working in the JSC. Your only issue is a divided view of whether your conduct was gross misconduct. It's the issue, really, and the findings that came after that. They say that is a problem, it disqualifies you. But let's assume MK is bold enough, which it is. They say, no, we look at your experience, we want that experience. Your transformation of the Western Cape judiciary is legendary. You are the only judge in this country who was able to say with a straight face that there is racism in the judiciary. Now, and then you used your position to change things in the judiciary. And if you go to the archives of the Office of the Chief Justice, you'll find that the running of this division was commended as one of the best run divisions. So MK says, we are renominating you. The National Assembly says, no, actually it's true. We are voting for you again. There is now contempt. Contempt is coming their way. Because I can see a crafty lawyer somewhere coming up with the theory that MK's position of insisting to nominate somebody who's a disgraced former judge is in fact not consistent with the judgment. I don't know what the judgment is going to say, and I shouldn't until it's written. But what they are asking the judges to do, honorable judges to do, is to do that, to introduce in the National Assembly the tyranny of the majority, to direct how the majority should think. The majority members should think as the JSC thought, with dissenting views. Remember the JSC had a dissenting view? Both the 2009 and the later JSC, they had different views about whether this constitutes gross misconduct or not. The National Assembly must be accorded that same respect of differing on whether or not the issues that pertain to Judge President Hlophe are relevant at all, other than the one issue which is relevant, his membership of the National Assembly. I've already dealt with the fact that the lawfulness of the impeachment is still a subject of pending litigation in different courts. As I said, there is no application to reinstate the Supreme Court of Appeal yet. When the funds are available, that application will be reactivated. There are no funds to raise for the appeal. So when that is done, then it would. And Honorable Justice, I just want to paint this picture. What the state placed Judge President Hlophe is inimical to the dignity of the office of the judge. Because essentially what they were asking him to do was to go and look for money elsewhere. So Judge President Hlophe could go and look for money from a rich person who litigates a lot in this court and get a lot of money to litigate further his impeachment. That's undesirable. That is why we still are complaining about the fact that the state has a duty under Section 1654 to make sure that judges who face misconduct hearings are supported. Because you're not supporting the judge, you're supporting the principle of judicial independence. But that's not for this court to decide yet. And then the question that we raised is relates to whether the interdict sought would infringe on the right or privilege or freedom of speech of NPs. I've alluded to the fact that if an interdict is granted, Judge President Hlophe is under a hammer of contempt if he exercises his duties as a member of the National Assembly in the JSC. He would be in contempt. And that, not only that, if, as the scenario I postulated before, the National Assembly is dictated to by the courts, that they must ensure that a process is set up that would look at Dr. Hlophe's irrelevant history and decide based on that whether they should designate him. Let's assume they did. It has a freezing effect. It has an impact on their free speech as different parties. So we're essentially asking for an order that when the National Assembly debates the issue of Judge President Hlophe, this is what they ought to say. Yesterday it was dramatic to hear what different members of the Speaker should have been saying in advising the National Assembly. Because according to the scenario postulated by the judge presiding to the speakers to the Speaker's Council, the Speaker should have said, wait, aren't we making an error in processing this name forward? Shouldn't we consider A, B, C, and D about this man? I'm paraphrasing it with respect. But firstly, that's what happened. But secondly, the interdict would have an effect on the rights of the members of the National Assembly in their capacities. There are various capacities, and they in the National Assembly they are honorable members. But we all here can't vouch whether they are saints or sinners or there is a mixture of different people from different experiences of life, and that must be that must reflect. It must be the case that the House is comprised of different people from different walks of life, different experiences, and all that. That must be the case. But I would commend this court to a judgment of the Constitutional Court, the DA versus Speaker of the National Assembly, 2016, Volume 3, SA 487, from paragraph 11. Justice Madlanga, writing for the majority, says, South Africa is a constitutional democracy, hard-won democracy that came at a huge cost to many, a cost that includes arrest, detentions, torture, and above all, death at the hands of the apartheid regime. The importance of our democracy, therefore, cannot be overstated. It is the duty of all, in particular the three arms of state, jealously to guard that democracy. Focusing on Parliament, the pluralistic nature of our parliamentary system must be given its true meaning. And if you want to read further down, it's brilliant in how it explains the role of Parliament and how Parliament must be left to its devices. The only thing that makes Parliament a parliament of the people is its ability to debate freely issues that pertain to it. But in this inquiry that is postulated, this ad hoc committee that is postulated of the National Assembly, what are the rights of Honorable Member Dr. Hlophe? Or does he appear there and say to them, guys, you're worried about my eligibility. Let me tell you who I am. This is what I've done. This is where I have. This is what I have. Is that how our National Assembly is going to function? Well, the Constitution doesn't say that it should have functioned that way, because it simply says you're a member of the National Assembly, you can be designated to a body like the JSC. So this part of the judgment from paragraph 11 to 17 deals largely with the issue of of Parliament and why it is a body that should really have the freedom to debate issues and to reach the decisions that it reaches. We say that an interdict against a member of Parliament would really be just inimical to our constitutional scheme, because what you are saying to the judge is that he cannot perform functions that he is assigned by the Constitution to perform in terms of the Constitution. You are not simply stopping him from going to the JSC. You are stopping him from performing his functions as a member of the National Assembly in relation to matters that have to do with the JSC. So, the National Assembly would perform its constitutional obligations if it were directed to do so under the hammer of contempt. If they don't perform the functions this court says it must perform, they are likely to be held in contempt. And we say that is an effect on the rights of the National Assembly at different levels. I want to then deal with this notion that's been raised by Corruption Watch. It's similarly been raised in heads of arguments by Freedom Under Law. That the reason why you ought to intervene in the affairs of the National Assembly in relation to its designation of Judge President Hlophe is because Judge President Hlophe is unrepentant. President Hlophe has not repented. Now they haven't told us which altar he should go to in order to repent. They haven't told us which God he must go to in order to repent. Well, the Constitution perhaps. But it's an extraordinary submission to make in light of what Judge President says, in light of what Dr. Hlophe says in his affidavit about his commitment to judicial independence. DA will never believe that Judge President Hlophe his commitments are valid, and they may have reasons for it. Well, similarly with the FUL. But under oath, Judge President Hlophe says, I'm going to use this position I have to promote judicial independence. One thing I'm going to make sure is that no judge is subjected to the tyranny, to the kind of impeachment that he was subjected to. Why is that being unrepentant? But in any event, is repentance a requirement? Is it a requirement for, okay, let's assume he offered his repentance. He said, look guys, I'm sorry, I'm really sorry. I'm really sorry. This is what happened. I won't do it again. Would he now be suitable, according to the Corruption Watch and the theory of the DA, of FUL? There is no requirement of repentance. There is no qualification of repentance that is required. Just like there's no qualification for repentance for any other member of the National Assembly. None of them go there under a cloud of repentance. We shouldn't impose qualifications that are not there. The FUL says that a cost order, a punitive cost order, ought to be awarded against Dr. Hlophe. But that's a familiar refrain. I've been against the FUL in most cases. That's exactly how their cases read. They're asking for punitive cost orders all the time. And they say extremely disparaging things about President Hlophe. Well, I called him President Hlophe, I'm prophetic in it. So they say Hlophe should be granted a cost order of a punitive scale because his inclusion in his affidavit of a number of false, scandalous, vexatious, irrelevant, and gratuitous. One word there would have been sufficient. But of course, for dramatic effect, this is what they do. Attacks and false allegations against freedom under law. Retired Judge Katalia, and they had to draw in judges, and retired Judge Krikler. But look at the references under those heads of those statements. Look at the references. They are made in reply. And you will see why Judge President Hlophe, you will see why Dr. Hlophe responded the way he did. Here is how they describe him. Other than describing as a disgraced judge, this is the big thing when they factual background. Dr. Hlophe is a disgraced former judge. Then they go on, they say, in addition to the serious issues, the exceptionally serious nature of the findings against Hlophe. And please, I'm not belittling the serious findings that were made by the relevant institutions. I'm saying Hlophe's view is a different one, and he's taking it to the relevant bodies in order to test whether they were correct or not. He's allowed to do that. Then they say, which is a favorite of FUL, in addition to the Stalin grant, I don't know where they discovered this word from. It features in every case that I'm against them. They say Stalin grant legal tactics he has employed. Judge President Hlophe, sorry, Dr. Hlophe has no money to actually promote his cases. Stalin grant is defined as a tactic used by rich people, like the FUL. Well, they have money they get from very rich people. So they accuse Hlophe of employing Stalin grant. They say Dr. Hlophe has conducted, and I want to really, for the court to pay attention to this, Dr. Hlophe has conducted his defense in a scandalous manner and made scurrilous and unjustified allegations against various senior judges, as well as the judiciary as a whole. He has done so without any factual or legal basis. Many of the cases and arguments that Dr. Hlophe brought were so hopeless that his attempt to advance them could arguably be unethical. Now pause there. If you want to find the evidence for these allegations, you go to the reply affidavit. That's not fair. That's not fair. That's not how pleading should be done. But because they have taken this attitude that Hlophe has no dignity, he must just be insulted at every opportunity they get, whether outside the courtroom or inside the courtroom. This is how they're going to deal with him. It's reckless litigation to say that he has adopted Stalin grant because he's asserting his rights. They have the privilege, and if one looks at what they've said, what we've said in our founding affidavit to the Constitutional Court, we will make that story consistently as long as this matter is before the courts. The role played by FUL in having Dr. Hlophe removed from the bench. The role that they played. There's a whole chapter on it that will deal with it, where they say they caucused with different, they campaigned basically to have Hlophe removed. So I really think that it's unfair to call his response, oh, this was the founding affidavit. So in order to find the evidence for this Stalin grant, this alleged Stalin grant tactic, you've got to go to the replying affidavit. So when he reads it, this is what he gets. He doesn't know which judges are against various senior judges, as well as the judiciary at all. They don't even tell us exactly where he insulted the judiciary. No facts are pleaded, with particularity for him to be able to deal with the issue. So he complains about it. He complains most profusely. But it's not fair. It's not a fair criticism of a litigant, where in certain instances he won his cases and others he lost. To say that he brought hopeless cases, that his attempts to advance them could arguably be unethical. What does that actually mean? I mean, what does it convey? Is this how much disdain they heap on a human being? Do they even see him as a human being? The manner in which FUL treats Hlophe in litigation is astonishing, but not surprising. I will restrain myself from saying why it's not surprising, because I still have to make that case when we come back in another court against FUL. And bear in mind, Honorable Justices, the only party that has opposed the applications of Hlophe and have been granted the status of a respondent, not an amici, not anybody, is FUL. So Hlophe, Dr. Hlophe could cite the JSC because that's who he's targeting. FUL will come in and they ask to be respondents. Oh, they've been given. The judgment says they are now respondents in all cases that involve Hlophe. So there are a number of reasons why this case against Dr. Hlophe should be dismissed. The court will know that Section 1, 2, and 3 of the Constitution, read compositely, makes it clear that South Africa is a democratic state founded on, amongst others, the supremacy of the Constitution and the rule of law, universal adult suffrage, a national common voters' roll, regular elections, and a multi-party system of democracy. Any conduct inconsistent with the Constitution is invalid, and obligations imposed on it must be fulfilled. All citizens are equal before the law. What we're being asked is to fashion a special law for Dr. Hlophe, so that there is further investigations that are conducted into his suitability to serve in the JSC. But it's also worse, because what's happening here is that there's speculation after speculation. One of the speculations that they make is that, if Dr. Hlophe appears in JSC, what's going to happen? There are certain candidates who are going to boycott or who are going to refuse to be interviewed by the JSC if Dr. Hlophe is present. Or they would question his involvement there. Well, let him deal with it there. And quite frankly, anybody who goes to the JSC and wants to choose the panel that interviews him, it's questionable whether they're worthy of the interview itself. But that to be made as a basis to remove Hlophe is beyond ridiculous. So the interdict that is sought would violate a number of rights that Dr. Hlophe has. It would violate his firstly it would violate his Section 19 rights, because what the DA and I mean the applicants in all their formations, what they are asking is that the court must uphold that the membership of Dr. Hlophe in the National Assembly is lawful, is in accordance with the Constitution. But as a member of the National Assembly, he cannot serve in the JSC. That's what they want you to hold. But that limits the very rights that he has as a member of the National Assembly. In terms of Section 19, the reason I say Section 19 is because he's a member of MK. MK has nominated him, so he has a right to, having been a member of MK, MK has a right to nominate him for any committee or any constitutional body which requires members of the National Assembly to be appointed. To put a barrier to that is really to limit his rights unduly. Here, what
So
is big,
what is that 19, was it 19 subsection?
I think
Is it three?
section 3, yeah,
3.
3B.
Thank you.
Yeah.
Thank you.
So if it is term for public office and if elected to hold office, there is a view that appears to be suggestive that it should be easy for the National Assembly and it's easy for them to designate any of their members to the committees of Parliament. And then it should be, when they designate members for any other bodies that operate outside Parliament, in the sense of the JSC, a different criteria should be used. But I don't see the logic. Firstly, Parliament's engine is through committees. Those people work hard for us. Those committees play a critical role. In fact, Dr. Hlophe was impeached through the actions of a portfolio committee. That's how powerful they are. A committee of Parliament recommended to the National Assembly that Dr. Hlophe be removed. Now, and in that committee, there were all sorts of people who were conflicted, but that's another story for another day. An interdict would violate the NA, the National Assembly's authority. In other words, what the court would be saying is, we understand your decision, but your decision must not be implemented, because one of the members you have designated must not perform the functions that you have assigned to him. So if the National Assembly wants a feedback from the 6 members of the National Assembly of what happens in the JSC, Dr. Hlophe won't be part of that. And that can't be right. The National Assembly is entitled to the experience he has as a judge, is entitled to the full use of that experience. Let me close with the issue of costs. Dr. Hlophe must be awarded costs. He's here not because he wanted to. It's been dragged here. So whether he loses or he wins, he must be given costs. And the cost should be a cost of 3 counsel, especially for the gratuitous insults that Judge President was subjected to. To say that we make unethical submissions or unethical legal arguments is below me. I mean, I'm not going to, in fact, even talking about it, I'm not going to dignify that because it's not made by Ms. February. If it's in the affidavit of Ms. February, but I do not believe Ms. February would have made that averment without the advice she gets, because the advice she gets is from lawyers who know this case, who say to him the arguments made by Dr. Hlophe are unethical. We get targeted for those kind of insults. What unethical submissions have we made? They don't point them out. It's not fair that they don't love Hlophe and we don't expect them to. But why target his lawyers?
Just one question there, Mr.
Yeah, look,
Masuku. Regarding your averment, whether he wins or loses, what about the usual rule of costs following the result?
It's not unusual for especially the NGOs to make that kind of prayer for the courts to consider. I'm making the call for costs even if he loses, because Judge President Hlophe is not brought himself here. the cost he has incurred to defend this case is because he's been dragged to the courts. If he had not defended the case, you would be asking the question, but he's not defending it, so what? If he had simply said, no, I'm going to stay as a member of parliament, the courts can do whatever they want. We are really here to assist the court to come to consider a good decision on whether an interdict is warranted, or even an order declaring the National Assembly's decision is constitutional. He has had to incur costs that he didn't have to incur. And this is how they drain you out. They will consistently litigate against you. And I'm sorry, I mean, you know, this is what happens when in this world of theirs, that once you are a target of their fancy, they will consistently without flinching attack you, drag you to court. In fact, we do have it in the FUL, that at some point they want to claim all the costs that were paid by the state against Judge Hlophe. So if the similar approach to the Zuma case, where if the costs that Hlophe incurred defending himself were amounted to 30 million, so FUL will be doing that. The point is draining him financially. Whether he wins or loses, the courts are like to say our NGOs, BioWatch, we had an interest in the Constitution, we're defenders of the Constitution. What has Hlophe been doing here? So I'm saying it's important, in the principle you put to me, Madod, would not be fair towards Hlophe. And because you have a discretion, you have to consider how Hlophe has been treated here. He's asked to repent. He's a disgraced judge. This is another platform for berating him. He's moved out of the judiciary. He's no longer a threat to their interests. But so why continuously drag him to court when he's now performing his functions in a different role? I think I have managed my time well. If I say I stop here, but before I do, let me see if there is anything I am leaving out. Yes, even the allegations that Dr. Hlophe is using Stalingrad approach, just with reference to the cases that have criticized litigant for being Stalingradist. Just do an analysis of the cases he has brought to court, why he has brought them, how he has brought them, compare and see whether there was any Stalingrad approach. Besides, Stalingrad presupposes that you have money. He doesn't. The Supreme Court of Appeal case had to lapse because he couldn't raise the 600,000 that was required. And yet they insult him and call him, because remember, he's a former judge. You're looking at your colleague, a former colleague, sorry. And what they are trying to present as your former colleague is somebody who's totally unethical. Other than the fact that he was disgraced by the JSC and removed in the way he was, look at him again. He's coming to you with a Stalingrad approach, abusing the court. How is he abusing the court? By being here? Or by being in the court that they have been participating? Not on the basis that they are complaining about Stalingrad, but on the basis of the merits themselves. So in every case we've dealt with FUL, there have been merits that have been debated. When Hlophe loses, he loses not because his arguments are what they call unethical. It's not the right way to treat colleagues, to call their arguments unethical. And this is what they are saying. And they quote somebody, the reference they are making is a reference to Owen Rogers. It's not right. And I think it's important that you realize too that what Dr. Hlophe has complained about is the imprecise pleading that is raised in the founding affidavit of what they say he's wrong for. And when Dr. Hlophe complains about it, they then give a reply in which they start to give examples. Here is the example. Here is the example. Here's the example. Here's the example. That's not how pleading is done. If you allege that I'm doing Stalin grant, tell me which cases you're talking about, so I can respond. If you say I'm raising unethical arguments, tell me which those arguments are. Don't just raise a statement insulting me. And this is why I think it's important to give an order, whether Hlophe wins or loses, an order that his costs are going to be borne by the FUL. At least, FUL from the website, they get money from very affluent organizations. Honorable Justices, these would be the submissions for Dr. Hlophe. There is no basis for an interdict to be granted, and that application should be dismissed with costs. There's similarly no basis on which the National Assembly's decision to designate Judge Hlophe as a member in the National Assembly in the JSC should be revoked or revised or set aside. We would ask that the court gives that order. But sorry, final submission. Just 1 minute. Judge Presiding asked the question about whether the dismissal, whether it in relation to the two applications, the fact that FUL is asking for a final order, and what should be, or how it should be dealt with, and whether the DA is asking for an interdict. If you dismiss the interdict, which you should, which you submit you should, then we submit that for the purposes of Judge President Hlophe, that would be it. If you decide not to deal with the FUL's case, then you don't deal with it. Although arguments have been advanced, probably would put in that you deal with it. But the complaint raised at the beginning was a valid complaint that these cases should not have been running on the same courtroom. Precisely because now we have three cases where there's got to be some understanding of how you would deal with it. So if you hold that the National Assembly's decision was unlawful, then perhaps an interdict won't be necessary, because once you set aside that decision, what is the need for an interdict? Because that means the decision on which Hlophe would have gone to the JSC is no longer there. The interdict is no longer necessary. So if you uphold the FUL's application, then the interdict must similarly be not necessary. You only give an interdict against Dr. Hlophe if the argument is that, irrespective of what this court says about Part B, Dr. Hlophe will be seen in the doors of the JSC, which is obviously would be a ludicrous suggestion. Dr. Hlophe intends to play a very big role, and that role, I'm sure, terrifies others, but it makes others a bit more happier, especially MK. What they are asking this court to do is extraordinary. If the National Assembly were to today elect Dr. Hlophe as president, because the president appoints judges, they are suggesting that there will be a basis for another inquiry into how you appointed a president who was a former judge. How should you do that? Because he was impeached. So if he's going to appoint judges, so 165 is implicated. I say that with tongue in cheek, but it's not too far-fetched. If he's appointed, if the National Assembly votes him as a president, these arguments will come to haunt us again if the court doesn't make a ruling in our favor, which is that this application should be dismissed. Those are the submissions.
Thank you, Mr. Masuku.
Thank you. I'm sorry, Judge. I didn't ask my opinion. Thank you.
Mr. Hlophe.
Good morning, Justice Parker, my lady. May I proceed?
Yes.
Thank you very much.
We have 15 minutes before tea adjournment.
Okay,
And
so
we
let
shall
me.
adjourn
That's
at
perfect.
11.
That-
But you may proceed.
Yes, okay. Yes, well, if the need arises, I'm going to collect all my credits from, starting from the emperor
Let's leave the credit.
to Mr. But there's also a charitable reason why that should be considered, because I'm going to allow one of my juniors to deal with a specific issue. So that's why I was saying the 15 minutes that you're talking about is perfect, because then I can do the introductory part. Maybe just to set the scene. Now, this matter involves, everyone has said, complex, novel, all sorts of adjectives have been used to describe it. But, and there are many sections and subsections and topics and subtopics and so on. So I'm just going to try to do a signposting of some sort, so that there's a logical flow to what we're about to present. Lady, my lords, ultimately, and I'll deal with this when I deal with the merits, there's only one real issue that permeates the entire issue, and that's the issue of rationality. And the reason for that is that this entire case is, I mean, at face value, even people walking in the street who have never seen the door of a law school will tell you that there's something fishy about this. Why would the court want to deal with what is happening in Parliament and so on and so on? So they might not know the words separation of powers. But they'll say, but this thing was happening in Parliament just now it's happening in a courtroom. What's going on in this country? So the separation of powers permeates everything that is around this case. Everybody, literally, that I've spoken to about this, from Uber drivers and anybody, ask the same thing. But Parliament has done this thing. Why are you busy debating in court? This court, or the court in South Africa, should never allow itself to become the appeal tribunal of the National Assembly. Because that's what is being done. Our courts are being turned into a joke. A political party goes to elections, wins 20% of the vote or whatever, it goes to Parliament, where it should go. It objects to the designation of Dr. Hlophe, as it is entitled to. it loses the vote in the parliament of the people. And then what does it do? It runs to court. What is that? They say with a straight face that as soon when that vote happened, they went to their lawyers. That's what they say in their own affidavit. So the trigger to this application was the losing of the vote in the National Assembly. Imagine, close your eyes and imagine if the DA had taken that debate to the House and won. Would you be here? No. Even a 3-year-old child will tell you that. We're only here for one reason and one reason only. They lost a democratic vote in the parliament of the people that represents all of us. This is not parliament. You are not elected representatives of the people. How can unelected representatives of the people be the appeal body for the represented people of the representative, the body that represents our people? How can that be? What is that? We have elections here. The only reason we have something called parliament is because we can't all 60 million of us, every time we make a decision, we have some mass meeting of 60 million people. So we have representatives, but those 400 people are us. They are us. So when they take a decision, South Africa has taken a decision. That's it. There's nobody, it doesn't matter what you are called, whether you are the Chief Justice or the Chief Magistrate or the Chief or the Speaker or whatever it is. You cannot overrule the will of the people of South Africa. The people of South Africa have a right to be wrong. And nobody can do anything about it. If they elect me to be whatever it is, you may think that I'm the most useless person or whatever. But there is nothing you can do because the people of South Africa have made that mistake. It will be one that we have to live with until the Constitution says it must be rectified. Anyway, so we have what is this thing called rationality? See, rationality is not what we say when we talk in the street. No, that's irrational. No. In the legal world, rationality simply means whether the process that was adopted by the National Assembly accords with the purpose of the provision. That's all. Now, you've not been told what is the purpose of the provision, and you've been lied to as to the process. The process is very, very simple. The Speaker of Parliament, nobody has dissented from what the Speaker is saying. The Speaker says, we did not rubber stamp the decision. And the Speaker doesn't even have to say that, for God's sake. It's in the record. It's in the record. It's all over the record. Justice Bakwa said yesterday to one of my colleagues, are you saying that they debated the issue, but they fell short? In other words, they only dealt with the issue of the qualifications. But that is not borne out by the record. The record actually shows the exact opposite. The issue of the qualifications was not debated by anybody. Everybody, even those who hate Dr. Hlophe, said, we accept that he's an excellent jurist and is well qualified. We accept that. So that issue was never debated. The only issue that was debated in Parliament was the issue of the impeachment. That's what that debate was all about. For the first time in 30 years, the Chief Whips Forum said, let's take this thing to the House. Why? Because for the first time in 30 years, we were not agreeing in the Chief Whips Forum, as we normally do, that it's automatic, that somebody, once there's a referral by a party, it's automatic. For the first time in 30 years. And because they could not agree, not about qualifications, they couldn't agree about the issue of impeachment. They said, let's take it to the House. I think it was Honorable Frolic who used the best word. Said, well, it's the first time this is happening. The House is the arbiter. That's what he said. So let's take it to the House. For what? For a debate. So how can anybody, FUL, comes here and says, I think it's paragraph 2 of their heads of argument, we are here because the Parliament failed to consider, they use that word, underline that word. You're going to hear a lot about it. Failed to consider. That is a complete distortion. Parliament, whether they came with a right to the right conclusion or whatever, but how can you accuse them of saying you failed to consider that exactly what they considered? Everybody stood up there and said, oh, we've never had this situation about an impeached member, The word impeach is there. So that's all they were debating. So they considered, you as the judges are not allowed to go beyond that. Once Parliament discharges its duty to consider, it's not for you. Let's say they consider and then they come out with the wrong decision. That's not your job. Your job is to say, did they consider as they are required to do? Yes or no? If they did, they did. And they did. And what you must do is to go to the speaker's, for shorthand, instead of going to the record, if you just go to the speaker's explanatory affidavit, you'll see there, I think there's Mr. Vessels, I think it's from the Freedom Front, who says that there's no legal impediment to this, but ethically I'm against it. There's a Mr. Maimane, who says that this has never happened and there's a lacuna. There's a Mr. Swart from the ACDP who says that there's no legal impediment, but we are seized with this matter. There's Honorable Shivambu, who says that the convention, who talks about the convention. And then there's I think it's Mr. Machakis or something from the DA, who obviously says what the DA is saying. But here are two telling things which I wanted to mention before we go to tea. One is that the DA, if you go to, to the speaker's explanatory affidavit, which you'll find this particular reference is It's TD4, which is it's actually the minutes to the Chief Whip's Forum.
We have it.
You have it? Okay. Let me just paraphrase. I'll find the case line reference. Mr. Machakis. Oh, no, Mikalakis, sorry. Mikalakis, yes. From the DA. This is what he said. Now they come here and say something completely different at the Chief Whip's Forum. Say, Mr. Shivambu indicated that the previous meeting it was proposed that it's 05-84, sorry. It was proposed that a political party should not interfere with the nomination of another party. There was no objection and so on. Mr. Nguban expressed surprise that there was disagreement. And then here's the DA person. Mr. Mikalakis stated that he agreed in principle that parties should not interfere with each other's nominees. But in that specific case, his caucus, that's the DA caucus, did not agree with the candidate for moral reasons. Moral reasons. We must sit here, all of us, honorable judges and so on, because some party had moral objections. And between down here, where there's parliament, and this building, it changes to a legal reason. No, man. So this is a political, as the speaker says, it's a political decision. And it is not true that what was put to my learned friend, I think Mr. Masuku, that the political decision was the MK decision. No. The speaker says the decision by the National Assembly to designate Dr. Hlophe is a political decision. It's a political decision. By the way, the decision to impeach him was also a political decision. So let's not elevate it as if it's some godly decision that says that objectively Dr. Hlophe is a person who has got some inherent wrongdoing. It was a political decision. If that impeachment happened now in this parliament, Dr. Hlophe may not be impeached. So it was a political decision by a particular balance of forces, which was dominated by the DA and the ANC at the time, before the ANC was dethroned from power in February this year. So let's not elevate it to something, oh no, no, it's a political decision. Some of those people didn't even know what was happening, they just vote. Hey, siang up, oh, and then they vote. And on the basis of that, you want to condemn a person for life beyond the grave. Beyond the grave. You have condemned him, you have vilified him, you have booted him out of his job, and now you go to the grave to dig the grave and say, I want to kill you again. That is what's happening here. Let's not glorify it with these pieces of paper. That is all that is happening. It's a lynching of black people in the same way that lynch mobs we were doing in the South, in the United States. You want to lynch someone and not be happy with killing them, but you must hang them on a tree so that passers-by must see his body hanging like this. And you call it the rule of law. The rule of law, my foot. It's not the rule of law. It's the law of the jungle. And we're not going to have that here. So when we return, I'm going to ask my Leonard Jr. He's going to deal in the structure that I suggested in the heads, it goes something like this. We deal with the preliminary points, then we deal with the requirements for interdict, and then we deal with the merits. That's kind of the broad structure. And I want to say this, that the merits will only deal with them in the context of what, and that's why this case has just been turned upside down, unfortunately. The merits of this case we shouldn't be dealing with, properly speaking, but only to the extent that in the EFF versus Godin case, they say you must have a judicial pick. You are allowed, as it were, a judicial pick into the merits, but only for the purposes of determining whether the interdict should be granted. That's really all. But because of the chaotic structure, which I will deal with when I deal with the abuse of process, it looks like, actually we started at the tail end. We started by dealing with part B, which we shouldn't even be reaching. So Mr. Moela is going to deal with the two things. One of the preliminary objections, you'll remember, is the one that talks about the incomplete pleading, which says outer was not pleaded. So he's going to deal with that in that context of the non-pleading of outer. Because in our respectful submission, that should be the end of the case. If you don't plead an essential averment, that's the end of the case. But if we're wrong, then he's going to deal with the requirements of interdict to show that in any event, the outer requirements have not been established. Assume they were properly pleaded. So that entire section will deal with it. So that will leave me to deal with the remaining points in limine, which is abuse of process. Locus standi I'll touch on. Agency I'm not going to deal with it because there was a suggestion, although I'm going to say something about the full application regarding agency. And then I'll deal with what I call the pick, the judicial pick into the
Yes.
Are you not taking our tea time now?
yes. we can take it.
Court adjourns.
friend Mr. Muela to deal with the sections that I've outlined. Let's go, please.
Thank you.
Good morning, Justices.
Morning, Counsel.
My learned senior has set out the tone for this matter, demonstrating that this is about the democratic will. In other words, it's about the democracy and not democracy. So now, I've structured my argument in this particular fashion. I will deal with the traditional requirement in Sitlukhelo versus Sitlukhelo. Those are the 4 requirements. I will then expand into the outer requirements that are additional to Sitlukhelo under the current circumstance. If we are wrong in all this, I will complete by demonstrating that the court retains the discretion. Even when all the requirements are met, you can still refuse to grant this interdict. So the story does not end by meeting the traditional requirements, including the outer. So, but let me just start by dealing with the outer requirements, because the outer requirements, we deal with them in 2 broad topics that are interrelated. One is the failure to plead the outer requirements. So I'll start vice versa. Ordinarily, I should be starting with the Sitlukhelo and then transcend to outer. But I'll start with the outer because if you start with the outer and you agree with us that the case has not been pleaded, that's the end of the case. That's the end of the matter. It matters not whether the Sitlukhelo are met or not. But under this circumstance, the case should end there. Then, the point that we make under the first broad aspect of the case not being pleaded, then followed by the case not being met under outer requirements. We say in paragraph 164 of the MK affidavit that outer requirements have not been pleaded. And there was no answer to that indeed they've been pleaded. So they don't contest that particular assertion. So we can accept it at least as common cause, that it was not pleaded. You can forget about the attempt in the reply, you can forget about the attempt in the heads. What matters is whether it was pleaded in the founding papers, because it's a salutary principle. You stand and fall by your papers. They should fall by these papers, which is the founding affidavit. There's no way out. Then, to give context to the importance of them pleading these outer requirements, you'll also see in the outer case itself in paragraph, let me start with the EFF, the Economic Freedom Fighters versus Godard, 2020, volume 6, SA 325 Constitutional Court. That's paragraph 48. So it will give context in failure to make out a case. It says that an interim interdict would only be granted in exceptional cases in which a strong case for that relief has been made out. So they must make out that case. And there's no way of making the case without pleading it. So if you don't plead the case, you can't make it. So that means that's the end of the matter. If this court agrees that in paragraph 64 of MK, we make an allegation, paragraph 64 of the answering affidavit, we make an allegation that you have not pleaded the outer requirement, because this case involves the separation of power in the merits and the separation of power harm under the outer requirements. So if that is not pleaded, then the case cannot be made. You should end that case then. That sentiment was repeated in the outer case itself, in paragraph 71. It says that a court should caution itself not to stall the exercise unless a compelling case has been made out. So I will not belabor that point. I'll then pass to another point. What do you do under the circumstance where a case has not been made out in the papers? You can raise the preliminary point. And from the beginning, this case must not even see the light of day. It must collapse there and then. And you will see that I'll rely on a case that it's not in our head, so I'll try to give full citation. The one that simply supports the proposition that you can raise this as a preliminary point. As I've said that in the outer case, we have two aspects. The one of preliminary point that you fail to plead, so it's a preliminary point. And then the other one, it's merit. You don't meet these requirements of outer. That is a case of Valentino Globe BV versus Phillips and another. 1998, volume 3, SA 775 SCA. That's page 779. It says that, just restating what I've said, there are a number of cases which recognize the right of a respondent, in spite of having filed an answering affidavit, to argue at the outset that the founding affidavit does not make out a case, does not make out a prima facie case for the relief sought. It can't be clearer than that. This is where this case must collapse. If there was any difficulty about the sensation, this is not sensational. Straight to the point, the court is assisted. Then, now, I'll come back to the issue of outer in the requirements. I'll just take it from the Sitlugelo and then finish with it, and then I pass my baton to my learned senior. So what you've been told that we don't have to plead the law. Sitlugelo has been pleaded. Sitlugelo requirements have been pleaded. 4 of them is the law. Outer has not been pleaded. You can't draw any distinction. That's the difficulty they find themselves in. Then let's start with the first requirement of Sitlugelo, which is then the prima facie right. Let me just put it up front that under this exercise we are dealing with the Corruption Watch and the DA, because that's the parties that are before this court properly. My learned senior will belabor that point in due course. The DA case, now we are going to their founding papers, that they plead, that they've met the prima facie requirement. At paragraph 67 of the founding affidavit, you will find that paragraph 67 of DA founding affidavit, you'll find that on page 01-26, that's a case line reference. So this is what they've pleaded. The right that is going to be asserted, they are protecting the right that is going to be asserted in Part B. That's one aspect. They say it in that paragraph. We are protecting the right that you are going to assert in Part B. In Part B, we know that they are going to assert review. And then some unclear assertion, the right to effective remedy and the right to independent judiciary. That's what they say they are going to plead. I mean, that's what they are asserting that they are relying on to establish a prima facie. But it presents them with difficulties. Because in the outer case itself, at paragraph 48, I beg your pardon, that's a wrong reference. In paragraph 50 of the outer case, that proposition was rejected in the sense that you can't rely on a right to review and you assert that that's a prima facie right. That's what outer says. But how do they try to counter that? Because they've realized that there's a problem here. Because that right itself, the Constitutional Court says that no, you can't rely on a right to review. And that was the judgment by Musaneke DCJ, as he then was. Then the counter to that is simple. They say that we have a prospect of success in Part B, therefore it's a prima facie right. that must be done in addition to the right that you are protecting. Sitlogelo case makes it simple. That the right that you are protecting, that you are inviting the court to protect, must be the right that the court must intervene now, not in future. You must protect the right now, that you are saying that if this court does not intervene, I will suffer irreparable harm. That is linked to this right. So you can't plead some other right and the irreparable harm is not connected with this. So all these 4 requirements, they transcend. Once you pick the prima facie right, you must tell the court that if you don't protect this prima facie right, not that prima facie right, this one, then you are entitled to an interim interdict. That's not the case here. In fact, there's incongruency in that pleading. They don't tell you what is the irreparable harm that will suffer if you don't intervene. In fact, the DA says that they suffer no harm. We suffer no harm, but they want an interim interdict. On what requirements? Because the Hlophe says you must suffer, the party that is asserting that right must be able to demonstrate that they'll suffer that harm. But the DA, they said it. DA does not assert any right of its own, so it won't suffer any harm. Then it's not entitled to this requirement. I mean, it does not meet this requirement. The paragraph that I was, but there's no need to read it, is the paragraph 50. I've dealt with that. Then, other requirements, they are so badly pleaded. They are so badly pleaded that I do not want to waste the court's time. So now, if...
Sorry, yes, you make it.
As the court pleases. Then, I just said that other requirements, they are really badly pleaded. Because if there's no harm, that means we can't intervene. If the harm is not suffered by the DA, you'll find that in paragraph 68 of the DA founding affidavit, case line 01-27. That's what they say. I mean, that's the same mistake that Corruption Watch does. At paragraph 91 of Corruption Watch founding affidavit, they said it crudely. We rely on section 33. They were so crude than the DA. The DA obviously tried to play with some fancy words. Corruption Watch said we are relying on section 33. That's what they say, and the rule of law.
38. Is it 34?
I beg your pardon?
Where is the line of 34?
Their paper says 33.
Well, they argued they said 34.
I'm not talking about their argument, I'm talking about their papers. So we
They
are
argued they said 34.
pleading. I'm talking about what they've pleaded.
Okay, they argued that they said 34.
Yes.
Let me read paragraph 91.1 of the Corruption Watch founding affidavit under the heading prima facie, and this is what they've said. Firstly, you won't find any 34 in that paragraph. Firstly, section 33 of the Constitution. That's what they're relying on. Section 33 of the Constitution, which provides that everyone has a right to administrative action that is lawful, reasonable. So we can forget about their argument, because you don't plead the case through the arguments, you plead the case through the papers. That's the right they are asserting. They must be found, like I've said, they must stand and fall by their papers. They can't stand by their counsel arguments, not even under oath for that matter. Then they address it with the principle of legality. So there's no, you can't, this is where you must find that particular aspect. Then, now, I'll then deal with the alternative remedy. In the aspect of alternative remedy, may I proceed, Justices?
Just 1 second.
Oh, yes. Without the
Yes, you can proceed, Counsel.
Thank you, Madam. Then now, I was then jumping to the issue of alternative remedy. Obviously, they simply assert that there won't be any alternative remedy if you don't intervene. But we plead that there are alternative remedies, and we list them. That these are the alternative remedies. You'll find such at paragraph 124 of the MK answering affidavit. That is -06. That is 06-38. That's when we find the suggestive alternative remedy pleaded by MK. So the duty then was triggered for them to reply in the replying affidavit to say that these are not competent remedy. They must tell this court why they are not competent, because MK dealt with that in their answering affidavit. They dealt with what Mr. Masuku also addressed, that you can run for election or sponsor constitutional amendment. You can seek a review of the relevant established convention in terms of Rule 9 of the National Assembly. You can lodge an interim interdict against the MK or the National, or even the JC, or you can write a letter to Dr. Hlophe. So these are alternative remedies. So there was a duty to then say to court that these are not effective remedy. And that has not been pleaded. So I'll just pass that. So now the last requirement of Situkhelo.
Are these remedies that they can be employed before the next sitting of the JSC?
I beg your pardon?
Are these remedies that can be employed before the next sitting of the JSC?
Yes, you can seek. They're seeking a review now before the sitting of the JSC. Paragraph 124.2 speaks about seeking a review of Rule 9 of the Constitution.
No.
So it can be done before that. And then 124.
That's not my question.
Yes, no, I was going to point out that was not the question.
Oh, no, I apologize if I missed the question. Can I just get maybe the rephrase of that question?
Yes.
Yes.
My question was, are these remedies that can be employed before the next sitting of the JSC? Because you're suggesting alternative remedies, that there are adequate alternative remedies available in this paragraph.
Yes.
So go through it and explain to the court why you're saying they can actually employ these ones before the next sitting of the JSC.
Going for the elections and so on, as
Yeah.
you're reading from your paragraph 124.
Yes, paragraph 24 says seek. Let me start by just answering. Let me give two answers. One, we are here because it's a review, and that review is happening before the sitting. So, and that's why they are approaching this court at least. They are coming to court before the sitting. So what we tell them here is the review, that they can still come before the sitting. So there's no special review than the other. They are all review, and they can all happen before the sitting. So that is a simple answer to that.
No, I don't understand it like that. Remember, you filed a composite affidavit in answer to the 3 applications that before court. So the requirement in question relates to the 2 applications where they seek an interdict,
Yes.
an interdict. So the question is, you're saying there are alternative remedies. Because they must persuade the court there's no alternative remedies available to them, and therefore the court should grant the interim interdict. Not so.
That's what they assert.
So you are saying there are alternative remedies available, and you list them here in paragraph 1 to 4. So the
That's
question is, can they employ these alternative remedies? Can they sponsor a constitutional amendment? This is not before the next sitting of the JSC. Can they seek a review of the established convention in terms of Rule 9 before the next sitting of the JSC?
Yes, FAL has done that. They are seeking a full review.
Can they lodge an interim interdict against MK before the next sitting of the JSC?
Yes.
So what I'm saying is go through it, and can they actually employ it? That's what I want you to discuss.
Yes, they can actually employ that. And it must be, firstly, let me then say that they must be the one to demonstrate that these remedies are not competent. Because, we are confined to the 4 corners of the pleading. So if we are saying that we were making an assertion, it must be countered in the papers. So they don't counter that. So from that point of view, we must accept that they've accepted them as remedies. Because if they don't say anything, otherwise they would have contested. But just to come to your ladyship's question, the interdict of the National Assembly, remember what they've done, they've tried to circumvent interdicting the National Assembly, but they say that inevitably that's going to be the consequence, that National Assembly would not be able to implement its decision. So we are saying because National Assembly is not interdicted, they could have interdicted the National Assembly. It's an alternative remedy. And I don't think that I must stress it further than that. And just to add on the issue of Rule 9, because I was doing Rule 9 review with pari passu with FAR, but they can also do it with an interim as well. So they are not forced to simply come for a full review. They can do a Part A and Part B to win Part B in terms of Rule 9 review. So that's an alternative remedy. They must demonstrate that how inadequate it is. And they say nothing about that. Then now, I'm just looking at the issue of time. I'm trying to reserve some time for my learned senior so that he can, because these points, they are interrelated. So some of the points is going to demonstrate in a great length. Then, let me then go to the outer requirements as the merits. Because the outer requirements establishes additional requirements to Sitlogelo. If Sitlogelo has 4, if you add outer, then notionally you have 8 requirements. 4 plus, it must be in the clearest of cases. It must safeguard the separation of harm. It must be in exceptional circumstances or exceptional case. And then there must be demonstration. All what must be. I then say that if we are wrong in these 2 aspects, Sitlogelo, including outer, then the court reserves its discretion. It is a residuary discretion. Unlike a final interdict, once the requirement of a final interdict are met, you must grant it. That's not the same with the requirements of an interim interdict. You still reserve the discretion. And we deal with that in our heads. Let me just give the reference. You'll find that at paragraph 100 to paragraph 121, asserting how you should exercise the discretion against granting it. And that's when my learned senior will also expand because they also go to the issue of merits, the broader merits. And if there is no question, that will be my address, and then I'll then pass my baton to my learned senior.
Thank you, Mr. Wall.
As the court pleases.
Yes, Mr. Hlophe.
Thank you, my lord. Indebted to the court and to my learned junior. Now, let's then quickly dispose of the preliminary points, such as they are, so that I'll end up with the merits and dovetail with what my learned junior has said. So, in other words, when it comes to the last 2 requirements that you mentioned of outer, the clearest of cases and the prospects of success, that's obviously tied up with the merits. And when I deal with the rationality test, I'll demonstrate that, firstly, this is not the clearest of cases, and secondly, the prospects of success are 0. The prospects of success in Part B. But before we do that, I want to address the elephant in the room, which is the abuse of process. And as we set out in our preamble and the introduction, I don't have to cite any authority for this proposition. The court knows that the court is entitled to dismiss the applications purely on the basis of abuse of process. This proposition has been put out in so many incarnations since the Hudson versus Hudson case of 1929. That's the leading case on abuse of process historically. And it has evolved until the recent Constitutional Court case of mineral sands, where all the principles of abuse of process were reaffirmed, including the great exposition in the case of Beinash versus Wixley. And the theme is the same. The theme says that a court should never allow itself, or rather its processes, to be abused for purposes other than what the rules of court were intended for, or which is the administration of justice. So if I have some political agenda to follow, I must call a rally or something. And you can't use the court to push another purpose, because the rules of the court have been designed for a particular purpose, which is to seek the truth and to pursue justice. And if you use the machinery of the court for another purpose, whatever that purpose is, then your case must be dismissed on that basis alone. And I know that I don't have to belabor that point, because that is, especially to the presiding judge, Justice Bagwa, because he sat in a case that I was involved in where the court found that there was a basis for that alleged abuse of process, and that was sufficient. And that was the case of the prosecution of Ramaphosa versus Zuma. And so there, what the court found, which I still find a bit difficult, but that's in the process of appeals, was that simply because this was the only basis of the alleged abuse, simply because the prosecution was instituted on a day that happened to coincide with the start of some ANC conference. On that basis alone, that it was an abuse. It didn't matter that in pages and pages the respondent, forget about Plascon Evans, the respondent says, no, I did that because it was the end of the year, I wanted to process my thing. It was only 3 weeks after I received the nolle prosequi and so on. No, abusive. Now compare that example, which really, as I say, it's hopefully the Constitutional Court will give us a hearing on this, to what we have here. An avalanche of attack from all corners at the same time. You know, the DA leads the charge, AfriForum, this side, FUL, Corruption Watch, all of them against one person, all at the same time. And they claim to represent the public, So why is the public, there's one public in South Africa. So if that public has been represented by the DA, why does FUL also want to represent the same public? And Corruption Watch wants to represent the same public? And AfriForum wants to represent the same public? It's pure harassment, deliberately planned, coordinated attack. And, they don't hide it, which is very good. FUL tells you, they say, we are aware of the DA application, but we're bringing our own. Corruption was the same, we're bringing. We are even aware of the AfriForum decides to go to the Constitutional Court. It's a clear strategy to impoverish these respondents. Because they must do an answering affidavit this side, and then there's another deadline, then the Constitutional Court, and for what? Just because they lost the vote in the National Assembly. We must bring judges from other provinces and everything. For what? To waste our scarce judicial resources because somebody lost a vote. And then we say, I'm sorry, Justice.
Before you depart from that
point, yes.
Mr. Mpofu, does that, well, yes, you are submitting it constitutes abuse,
yeah,
but maybe in a more technical way.
yes.
Does that exclude their right to act in terms of 38D?
No. That's not what I'm saying. Sorry, Justice. No,
Yeah.
I'm not saying that.
Yes.
I'm saying they even have a right to act in terms of 38A. Just like Mr. Zuma had the right, nobody, even in your case, you never said he didn't have the right to go to court. No, he did have the right to go to court. But he said in going to court, it was an abuse of the process. So let's not conflate the two things. Nobody, even in all the Hudson, in all those cases, nobody said, no, you shouldn't, you don't have, you are the special person who doesn't have your constitutional right. No.
So they do.
They do, of course. They have everyone, all of us, you, me, the NP, what you call the thing, SPCA, everyone has a right.
Yes, what I am trying to understand is then the abuse lying in the almost simultaneous.
Yes, on this aspect. On this aspect, I'm saying yes. As I said, former President Zuma says in his affidavit, they hunt in packs. So it's not some one day, like was suggested yesterday, FUL brought an application, and then, by some coincidence, the DA, no. This is coordinated. They say to you, we're all coming on the same day. And we're aware of the other application. If you're aware of the application, why do you need another application? That's what you must ask in your first place. There's only one Hlophe. If he's going to be removed by the DA, he's gone. Why do you want another application? And another one, and another one. So that's a clear strategy because they have money from the foreign funders that they have. They can do that, but Dr. Hlophe and MK don't have that kind of money.
Yes, I just wanted to understand.
Yes, no, I understand the question. And we say that it's hypocrisy because all this comes from this thing of the so-called rule of law. The rule of law is another red herring that gets bandied about. That thing is meaningless. There's no such thing, actually. It should be thrown out of the dustbin. Because apartheid was the rule of law. The Group Areas Act was the rule of law. The Separation of Amenities Act was the rule of law. So there's nothing magical. The rule of law must be good in its own right. You can't just go and fly some flag. From racists who tell us about the rule of law. Now, number 5 in our thing, we say MK feels strongly that these busybody applicants who claim to be the enforcers of the rule of law are notably silent when black women are murdered in cold blood by members of AfriForum and fed to their pigs, and many other criminal transgressions suffered by black people and the country at large at the hands of their own or their puppets. Now, that might sound to be an emotive submission, but it simply says that the court lives here in South Africa. It doesn't come from the sky. We know that there are certain causes that are ignored by these people. And there are certain causes and people who are pursued, as I said, beyond the grave by them. And former President Zuma lists examples, I won't go into that, of how he personally, in his affidavit, how the PEC came when he was supposed to be paroled. The PEC came when he was bringing another matter in KZN. The PEC comes whenever these things happen. And it must end here. you know. So the court must not allow its machinery to be used for those kinds of purposes, for political purposes in this case. Just as in the case I was saying, what really the court was saying in the case that Your Lordship was sitting in, was that the process of the court was being used for political purposes, in effect. Forget about the ANC conference and all that, but in fact it was saying the court process was being used for political purposes. So, and I'm saying this, if that is true, was true in that example, this is 1,000-fold of the court being used to pursue political objectives, particularly political objectives that people have failed to succeed in the democratic parliament. And then we say that, so just one by one, Corruption Watch, I've already made the point about the multiple, we've just debated the multiple applications. FUL is even worse, because we say their application is clearly not ripe. That's the point I wanted to make yesterday, and I was stopped from making it, and I feel that let me make it now. What we were trying to say yesterday, Justice Bakwa, is that you cannot, and when we do, our objection was that the FUL application does not belong here, and we can't bring that objection later, because it's a point in limine, in the proper sense. In limine is just some fancy Latin. It just means at the threshold. So it must be raised at the beginning, because you need a ruling on that, just like we did with the emperor. And in the case that Justice Collis did, the ZEP case, that's exactly what they did. The whole issue was Part A, Part B, then it says in the judgment. Then the court, it was raised, then the court took a short adjournment, and then it came back, and then it said, okay, we will proceed with Part A. It couldn't have done that at the end. You can only do that at the beginning. And that's how I was distinguishing that point in limine from the other points in limine which could wait, like abuse of process and whatever. But be that as it may, the point of the matter is that it is completely ludicrous to have an application and hear Part A and Part B on the same day. I mean, it's just... And in the case of AGVH Holdings...
yes, but remember just one thing, Mr. Hlophe.
Yes, Justice.
Your words, you can't hear Part A and Part B in one day.
Yeah.
What has happened here is at the risk of repeating myself, in respect of the DA and the Corruption Watch cases.
Part A cases.
Yes, Part A cases. And in respect of FUL, you might call it a Part B. But these are separate applications.
Yes, okay.
They are being heard on the same day. But it's not like a simultaneous in the same case.
No.
Yes, so that's what really makes the separation. So we are not hearing Part A and Part B, and that calls for a different finding for the different cases.
No, I'm sorry.
In order for in our judgment.
Yes.
So we will have to say something about each one of them.
Of course. Yeah.
But unless your submission is different, but in your words, when you say, but no, you can't hear Part A and Part B at the same time. That's not what.
Okay, let's forget the maybe it's the parts thing that is confusing. Forget about parts. You cannot. There's no court in its right mind that can hear an application pendente lite. That's Latin for pending litigation. You can't hear an application pendente lite in the lite and the lite itself on the same day. That's this is how it was described by, because I don't want to use words that come from me, Binsward J in this court. In that case of
citation?
AJVH Holdings, my lady, and versus Steinhoff. It's the Steinhoff, the big Steinhoff cases. It's 872 unreported 8276/2018, and then square brackets 2020 ZAWCHC 46 bracket 4 June 2020. And this is what he said. It does not appear to me, paragraph 16. It does not appear to me to be in any sense fitting or appropriate for action for interim relief pending the determination of a principal case, whatever you call it, the principal case, to be consolidated with the action in that principal case so that both actions can be determined contemporaneously. Merely stating this proposition shows it to be a nonsense. There cannot be any prospect of interim relief pendente lite being a real issue deserving a court's attention if the case for it is to be decided together with and at the same time as the principal case. Nonsense, he says. So why does he say that? Because by definition, and this is what I wanted to read yesterday morning. By definition, if you say, you see, Justice Parker, your example could work if there was some coincidence of cases. Here they tell you we know that there's a Part A case. Actually, not only do we know, we're asking you to please hear it on the same day. But we're only going to ask for what is the main relief in that. Call it what you like if you don't want to call it Part B. But we're only going to ask for that, the main relief, in other words, the review of the main relief in the DA. But let me just assist the court really with, to cut this to the chase. This application that they say they are aware of the DA says at paragraph 64. And you'll find that quoted at 17.3 of our heads. The DA accepts that it will not obtain final relief in Part B before the October interviews. Even if it is able to obtain a determination by this court, any judgment will be appealed, and it is impossible that all appeals will be resolved before 7th October 2024. Impossible. They don't say difficult, unlikely. It's impossible. The DA also accepts that the final relief, you call it what you like, final relief it seeks is of public importance, that the respondents must have a proper opportunity, that's us, to answer it, and that it should not be determined hastily. I never thought I'd praise the DA, but here, they are right.
Mr. Hlophe,
They are very right, that we must be given an opportunity to deal with, I'm sorry, Justice Dafro, to deal with such a matter, and not be slapdashed here and dragged to listen to a presentation of the main presentation. Sorry, Justice.
I think one must understand what has happened here. There were the three applications. The deputy or the acting justice president of this division made an order, and apparently by agreement, we were not there.
I was there.
These three applications be heard simultaneously. And you agreed to that, well knowing that full is asking for final relief and the others for interim relief. Now the proposition is correct, is that it would be wrong to make final relief and simultaneously interim relief, because it cannot work. We'll have to consider that. And that's why your protest was raised yesterday, and we said, let us deal with it on the basis that everybody gets an opportunity to argue the matter. We eventually, when we've got to give a judgment, we'll have to sort this out.
Yes, no, Justice, I'm with you. I'm all I'm saying, I'm not, that's what's under the bridge, whatever happened yesterday. I'm now doing what I was told I must do tomorrow. It's tomorrow now. So I'm saying that and I take your point, but surely, Justice Tafu, you know, just from your own experience as an acting DJP, that the case management. In other words, if I go to case management to your chambers with my learned friend, and I say, we then agree, no, the matter will be heard on Thursday or Tuesday or whatever, it doesn't mean I'm not taking away my right to object, to say this application should not even be here. So let's not confuse the case management, and I agree that was done and so on to get but it can't take away now our right to object to what has been described by this very court as a nonsensical approach. And the point, I'm sorry, Justice.
We know, for example, that MK hasn't responded paragraph
to the merits.
To Fool's application.
Absolutely.
We've seen that.
Yes.
And obviously that is something that will have to be considered by us when we write a judgment here.
Absolutely.
So I don't think we should carry on with this point any further. We understand the difficulties with this. Fool wants a final order today, whilst the others want interim relief. And we are mindful of that issue.
No, Justice, please forgive me. You might be mindful of that. But remember, I'm raising this in the context of abuse of court now. I'm not raising it for these procedural quibbles. I'm saying that to do that knowingly, knowing that it has been described as this, and to persist. You remember what we say in the MK affidavit? We say that we're not going to deal with the full affidavit. We ask for them to withdraw it, failing which we will do what I'm doing now. Point it out to be an abuse and ask for punitive costs. And they failed to withdraw it. That was friendly fire. Yes, we were saying yes. Yeah. So I'm raising it only in that context, but I take the point. I'm sure the court, even the questions you asked from my colleagues, I know the court is alive to this issue. So I'm not raising it from that point of view. And what I really want to emphasize is the fact that they say we are aware that there's a DA application. The DA application says we must be given proper time if we're going to deal with these complex times. But they say, no, we're going to court anyway. That's abuse of us. If the court wants to be abused, that's fine. But we don't want. We don't want to be abused like that.
Abused either.
Thank you. I would have thought so, my lady. But I just have to speak for this side of the table. Okay, I want to, mineral sands I've already referred to. The DA, I've already said how they abuse, because they are the worst abusers, because they were in Parliament. I mean, the others, you can say, well, they're NGOs, what else must they do? But those ones who are in Parliament and then come and want to abuse the court to be, as I say, its appeal tribunal. Now let's quickly deal with the issue of jurisdiction. If I'm correct on the abuse of court, of course, that's the end of it. Now, very quickly, my learned friend, Mr. Katz's issue on jurisdiction. Mr. Katz said he was in a lonely place. Just because one point in a matter, everyone is against him. Well, he must try and trade places with me. Well, that's what I do for a living, to be lambasted and vilified for representing people. So I don't have much sympathy with him. Now, the only reason that we part ways with Mr. Katz on the jurisdiction is simply the following. And I had a debate with him after court. Mr. Katz is, if the thrust of this case was the designation in 178(1)H per se, then Mr. Katz would be correct. In other words, if the crux of the attack, I know that 178 features strongly, and I'll deal with it. But how the applicants have pleaded the constitutional obligation issue is that they have based it on section 165(4) and 165(3), I think. So they're saying Parliament failed in its obligation to uphold the independence of the judiciary. That's really the crux of the obligation attack. Now, if that is true, then that power says all organs of state must do that. So it's obviously not a power that's specific to Parliament. It's all organs of state. So therefore, from the Nkandla case, it has been said that if the power is a generic obligation that Parliament shares with other institutions, then you can't say it's exclusive jurisdiction, because that 167(4)(e) must be restrictively interpreted. That's the main issue why we differ with Mr. Katz. But also Mr. Katz is wrong on another point, because he also says, well, what if the Constitutional Court, they go to the Constitutional Court and the Constitutional Court also finds that it doesn't have exclusive jurisdiction? But as we all know, in the Constitutional Court, there's another route to get in. If you don't have jurisdiction, exclusive jurisdiction, you can get in through direct access. So that wouldn't be such a crisis either, because in any event, it has been pleaded by AfriForum, I think, as an alternative. So that's why we say this court has jurisdiction. Apart from that, and let me dispose of another easy issue, PAJA. We also say PAJA doesn't apply. PAJA doesn't apply. We know that also that doesn't necessarily present a crisis, because if PAJA doesn't apply, you can go legality. But it's important for the purposes of this case to make it clear that PAJA doesn't apply. And Mr. Trengove gave us the definition of PAJA, but he fell short of one aspect. We base this, there are many reasons why PAJA doesn't apply, including the fact that the DA is not asserting a right and so on. I don't want to go into those esoteric reasons. I want to just deal with it at the level of the exclusions. PAJA says that in section 1, administrative action means any decision taken or failure taken by an organ of state or a natural juristic person, we know that, but does not include. And Mr. Trengove dealt with the first exclusion with his, the legislative functions of Parliament, a provincial legislature or a municipal council. And he says, no, these are not legislative functions. But that's wrong. Legislative functions doesn't mean just creating legislation. It means the legislative function that's been defined in the Fairshore case means that the businesses of Parliament acting as a deliberative body. I'm just paraphrasing the phrase. And in this case, Parliament, clearly we've seen from Hansard, was exercising its powers as a legislative body and a deliberative body. So we say that's a first exclusion. So PAJA cannot apply to those. PAJA applies if the legislature or the president or whoever was doing an administrative act, not a legislative act. But let's assume we are wrong on that. Go to the other exclusion, which they haven't dealt with, GG. So GG says, PAJA excludes a decision relating to any aspect regarding the nomination, selection, or appointment of a judicial officer or any person by the Judicial Service Commission in terms of any law. How can it be clearer than that? Any decision relating to any aspect regarding the nomination, selection, or appointment of a judicial officer or any other person by the JSC is excluded specifically from PAJA. So
yes, but is that applicable? I mean, at
in
the
this
end
case
of GG, it's by the JSC.
No. Of any person, not by the JSC talks about to the appointment, not to the governing sentence. I'll explain to you just now, Justice.
Yes,
It
maybe.
says, it says.
Reread that.
Yes. So sorry. Yes. Let me do. A decision, right? So that's the administrative quote unquote. Let's say it's administrative decision, but it's excluded. Yes.
Yeah.
Relating to any aspect regarding to the nomination, selection, or appointment of a judicial officer or any other person by the Judicial Service Commissions in terms of any law. In other words, the decision must not be confused to the appointment. It's a decision relating to the appointment by the JSC.
Yes, clear. It's a decision by the JSC.
Yes.
It's
Yes.
not by another body.
Yes, by another body, but relating to an no. I think we are completely at cross purposes. If I say there's a decision, let's say there's a panel of cricket selectors. Now you say any decision that relates to the appointment of a person by the cricket selectors. It doesn't mean it's a decision of the cricket selectors. What that is excluded. It's any decision, administrative decision relating to that second step. It's very clear.
Who is the decider in this GG subsection?
It could be any. In this case, let's make it concrete.
Yes.
It's the NA, National Assembly. So the National Assembly takes a decision that relates to any aspect regarding the nomination or selection or appointment of a person by the JSC. Okay?
Yes.
So that's what it means.
Mr. Mpofu, you have highlighted that, so I don't think we need to
the judges, I think, there's no point, yes. I think in good time, the judges will engage with the GG. Section 1, GG, that's all. And it's explained, in Hoekstra, it's explained somewhere in the text, that exclusion.
Yes.
Right. So it's excluded by, is it DD, the first one, DD and GG, I think. This is not a part of thing. But as I say, that doesn't help us much because legality, as we know, applies. Now, which then takes us to the crux of the case. And that is this. And again, I must, at the risk of repetition, say that I'm doing this for the purposes of the so-called judicial peak. Because you are not seized now, unless if you want to entertain the FUL application. You are not seized, at least from the CW and DA. They say in 100 times to their credit, you are not seized with the merits of the review application. You are only seized with it insofar as Justice Kabebe said you are entitled to a judicial peak. For the purposes of what Mr. Muela was saying, to demonstrate, for us to demonstrate that in any event they are unlikely to succeed in Part B. That's really or they don't have good prospects of success, which I think in a way is two sides of the same coin. Now, here is the thing. You remember when I was doing my opening address, I said it's a connection between the process and the purpose. And then I went through the process, and I showed that the process was flawless, at least according to the speaker. That the debate happened, and to lose the debate does not mean it has not happened. It happened. So you can't say the National Assembly did not consider the issue of impeachment. They considered it extensively. It just came out with a particular outcome. So if you don't like the outcome, you can't come to court and call it a review. A review is not about the outcome, it's not an appeal. It's a review of the process. So the process was followed, and the speaker has given us chapter and verse. I don't have to repeat that. But you can follow the process and be to 1,000%. But if that process does not speak to the purpose, then it's irrational. So let's talk about the purpose. What is the purpose? And nobody has addressed this. What is the purpose of Section 171H? Mr. Masuku should not be included in that slur because he I'll think about it. I think Mr. Trenkov as well also touched on it wrongly, of course. But on a more serious note, the purpose of is not any of these things. Mr. Masuku correctly says that so Section 170A, the composition of the JSC, must be seen as a very carefully crafted piece of work. I must say, this case actually, Mr. Masuku and I sat in the JSC for many years, but this case has allowed me to actually see things that I couldn't even see. For example, the fact that those 6 persons, it has been carefully crafted so that the 6 persons are at a minimum 3 of the ruling party and 3 opposition. That's not a coincidence. So when 178(1)H says 6 members of parliament, at least 3 of whom must be members of the opposition, it means they must go there as 50-50. It's a deliberate purpose. Why? Because it wants to accentuate the value in Section 1D of the Constitution, multi-party democracy. That's what it is. Otherwise, opposition parties would never see the light of day because they would always be outvoted. So it's constitutionally entrenched that you have to include opposition people. But the other thing that most people miss is the word at least. So everyone says, no, you must have 3-3. No, that's not what it says. It says at least, that means a minimum of 3 must be opposition. What does that mean? It means all 6 could be opposition. But all 6 can never be ruling party. Are we together on I think the numbers are 50, it's at least 50%, which means it's like what we do when we do women representation. So you say if you have 2 people, they can't both be males, but if you have 2 women, you can't say you don't qualify. It's fine. So it's like that. So you could have all 6 of those people being opposition members. They would be constitutionally correct. But the minute you have 4 of them coming from the ruling bloc, you are in breach of the Constitution. So that's what Chaskasin J explained this in 2002 in the case of Van Rooyen and others versus the state and others. 2002, bracket 5 SA 246, Constitutional Court at paragraph 42. He said the purpose of the section, he described the purpose of the section, sorry, those are my words, as providing, quote, for opposition parties to have equal say with the governing party for nomination from the National Assembly. In other words, a minimum of equal say, as I've described. The removal, as it is being sought here, of Dr. Hlophe will defeat that purpose. His designation as a leader of the opposition, Nochal, fulfills that constitutional purpose. So the JSC, you know, let me say this. The JSC, and this part has always fascinated me. If the JSC was not, if it was constituted in terms of legislation, it would be unconstitutional. The only reason why it is prescribed in the Constitution is so that it can be preserved. Because where in the world would you have a meeting where you have The President has 4 representatives. The Speaker of Parliament is sitting here. The Chief Justice is sitting here. All in one room. It's against anything we've ever learned about separation of powers. But because the Constitution prescribes it, then it's allowed. Because the separation of powers doctrine is misunderstood by people. Separation of powers says you may not have the one arm encroaching on another arm unless it is constitutionally permitted. So that's why the JSC survives, because it's constitutionally permitted. But anyway, to come back to the designees. Now, if you take one, it's like a puzzle or a house of cards. Now you take Dr. Hlophe, the entire thing collapses. It's not just those 6, because that thing has been carefully balanced in a particular way. If you take one cog, it collapses to nothing. So it's not as simple as the DA and Corruption Watch and FUL say, that, oh, you can somehow replace Dr. Hlophe. How are you going to do that? There's no mechanism. The NA is functus officio. It's done. I think my learned friend, Mr. Jamie, put it nicely. He said it's done and dusted. That process of nomination in the National Assembly. And then the next thing will be the absurdity that Mr. Masuku was pointing us to. You can remit, as Mr. Trenkov was saying, and then it will go back to the National Assembly, and MK has said under oath that they will not put another person. So we must read that to mean that they will still nominate Dr. Hlophe. And then what? We must come here again, then toing and froing. So but even that is hypothetical, because there's no process like that is allowed. You remember, I can't remember one of the categories where it provides for alternates, but not in this category of the NA. Yeah. There's another section where it says if so-and-so, I think it's the JPs, if so-and-so is not available, then they can send an alternate. So that's the first thing. The other red herring is this thing of, as I say, okay, I've already made that point, but let me just say that. And I want to save time. The dictionary meaning of the word considering. Considering means debating, taking into account, and we know those kinds of synonyms and phrases. Debating, taking into account, Now, and as I've already said, I don't want to belabor this submission. Anyone who reads the record cannot say that the issue of the impeachment was not taken into account, rightly or wrongly. So the next thing is the so-called rubber stamping. The Speaker of Parliament tells you in so many words that this was not a rubber stamping. She says the issue was debated. And that's just a matter of logic, by the way. Because if it was rubber stamping, then it would have been finalized in the Chief Whip's Forum. The very purpose of bringing it to the NA was so that it must be debated, and the outcome would have been the outcome. So it didn't matter what the Chief Whip's Forum. If the DA had won in the debate, that would have been it. Then the House could not have designated Dr. Hlophe.
What has been the response to the DA on the allegation that debate took place? Has it not been that we followed convention?
No. Yes, thank you. No. That's a big mistake. It is true, Justice Bakwa, that I think it was Honorable Zungula from the ATM and somebody from Al Jamaa. It is true that one or two of the speakers said, look, we have a convention and we must just follow the convention. But it's false to suggest that that's all that happened. Many people, including DA people and other people, referred specifically to the issue of impeachment and said, okay, we're here now. We know about the convention, it's all very well. But we're now in this unprecedented situation. And even Mr. Swart, who's a lawyer, by the way, from the ACDP, said, we cannot support this. But in the same breath, and I think Mr. Vessels as well, in the same breath they said, but there's no legal impediment to it. There's a lacuna. That's the kind of debate that was being had. Mr. Maimane says we must attend to this lacuna and we must put the rules in place and so on and so on. So it's just distinctly, it's a lie, to put it bluntly, to say that the impeachment issue was not considered, or that there was a slavish adherence to the convention. The convention, yes, was invoked by some of the people, but the others were decrying the lacuna, which is true. There is a lacuna if you want to look at it like that. I mean, our version is that there's no lacuna. The law is very clear, and I'm going to come to that now. The law is clear because what are the qualification criteria? The qualification criteria are two. You must be a member of parliament and you must be a member of the opposition in the context of this case. Now that's not, so it's not true to say there are no qualification criteria. And those qualification criteria, by the way, are very stringent because they are contained in section 47 of the Constitution and 48. There are at least 6 criteria that you must meet before you are a member of the House. That's why former President Zuma is not a member. Because in 47E, it says that you cannot be a member if, one, if you are not a citizen of South Africa, that's the first part. If you work for the state, you are in the service of the state. If you are a permanent delegate or something like that. If you are an unrehabilitated insolvent. If you are declared of unsound mind. If you have been sentenced, if you have been convicted for an offense and sentenced to more than 12 months and 5 years have not expired. And of course, the last one is in section 48. If you haven't taken the oath, the prescribed oath. So if you read section 47 and 48, it gives you the, so those are the qualification criteria. And that goes to the point that we make, that was made, I think, by Mr. Muela in the context of the requirements. That there's an odecral problem here. So you can't say that I accept his membership as a member of parliament. I accept that. So the DA should have challenged his membership as a member of parliament. They didn't. They should also have challenged as soon as it became clear that after his swearing in, he's being nominated for the JSC. They could have come to court and say, we hear that some illegality is going to happen, interdict it. They didn't. They could have interdicted the sitting of the 9th. They didn't. They waited until they lose the vote. So they could have said, oh, we now there's a sitting that the speaker is insisting on putting this thing on the table, and it's, please court assist us. They didn't. And we know that if they had won the vote, they wouldn't have come here. So the process that was followed is perfectly aligned to the purpose, which is what I've described, which is to get that 50-50 minimum and so on. So in legal terms, it might be, if we talk in the taxi rank, say, oh, that's strange or whatever. But irrational in the legal sense, it's not irrational because the process is directly linked to the purpose. That's all the law wants. And you don't do what Justice Chaff, Justice Bagwa and I'm accepting that in the spirit of engagement, was saying to one of my learned friends, well, why didn't the speaker, or maybe it was my learned friend, Ms. Hassan, why didn't the speaker do this or do that and so on? That's fine for purposes of debate, but that doesn't enter into the test. Because we were warned about that approach a long time ago in Pharmaceutical Manufacturers Association of South Africa, where it was said by, I think, Charles Carlson again, Jay, the court cannot or should not substitute their opinions as to what is appropriate for the opinions of those in whom the power has been vested. Let me repeat that. The courts cannot and should not substitute their opinions as to what is appropriate for the opinions of those in whom the power has been vested. As long as the purpose sought to be achieved by the exercise of public power is within the authority of the functionary, and as long as the functionary's decision, viewed objectively, is rational, a court cannot interfere with the decision simply because it disagrees with it or considers that the power was exercised inappropriately. That's not the function of the court. Because to do that would be to flout every rule of separation of powers. So it's not your job to say, I'm not comfortable with Dr. Hlophe sitting there. Well, some, as Mr. Masuk said, some are comfortable, some are not comfortable. It doesn't matter. But here, yeah. Yeah. So a court of law is supposed to do that. Sorry, Justice. I didn't see. I didn't hear.
No, you may proceed with your submissions for a minute.
While you are searching, okay.
Because you've got 2 minutes now.
Well, are we also counting the times when we were on stopping with the computers being charged? No, I'm joking. I'll need
it was not being charged.
A few.
The Wi-Fi that's so poor, yeah.
Yes, it's terrible. In fact,
we need to go back to Johannesburg.
We have to go back to the land of gold. Yes. Now, Justice Park, I am going to ask for more time, even without borrowing from that, just to wrap up some of these points, as far as the court is prepared to accommodate. Now, the point I was making, Justice Park, is that is again a misunderstanding. There are two misunderstandings that are often made by some of the lower courts here. It is this not heeding this warning in pharmaceutical, number one, but also not recognizing the difference between a review and an appeal. Because a review is not about the correctness of the decision. If it was an appeal, we could come here and say, no, surely it's wrong to have Dr. Hlophe and so on. No, this is a review. A review is about the process. Your job as judges is to say, was the process followed? Was it aligned to the purpose? Yes or no? Do we like the outcome? That doesn't matter.
Yes, you are quite right, Mr.
Right.
I'm not sure that there's a dispute
about the test. No, I'm not. I'm just emphasizing.
But maybe I just wanted to, in the context of what you are saying, refer you to 165.4
yes.
of the Constitution.
Yes.
Which I'm sure all around this table are aware of.
Familiar with it.
Yes. But for the sake of emphasis, just read it. Organs of state, through legislative and other measures, must assist and protect the courts to ensure the independence, impartiality, dignity, accessibility, and effectiveness of the courts.
Yes.
Now, when and this is not what the court wants to say.
Yes.
That's what the applicants are saying.
Absolutely, I get
that was not sufficiently paid attention to, for want of a better word, during the debate that we are talking about in the assembly. because, I'm paraphrasing what they say, taking into account not just the courts with these qualities, the dignity of them,
Yes,
the
effectiveness
partiality and so on. Those same goes when they say the courts, you include the JSC, and that attention therefore needed to be paid to those considerations, bearing in mind not the entire judiciary, but more specifically the JSC, and therefore deliberating or debating or whatever other word you'd want to use in those.
Yes,
Yes.
I get the point.
Now, we've had your submissions that no, this was done, everything. So, and the speaker also says yes, process was followed and so on and so forth.
The debate was held and so
yes,
on.
but if I understood some of the submissions by the applicants correctly, they're saying no, you expand on the debate in your submissions, and I'm generalizing here.
Yes, yes. No, I get.
Ex post facto, as it were. But your main thrust of your response was convention. This is how we do things here, kind of. And don't get me wrong, none of the respondents used those words.
Yes.
But essentially, that's what they were saying.
Yes.
This
No,
is how we do
I
things.
understand. Let me tackle it at 3 levels. Firstly, even if that was true, it would not be competent. If they were saying you relied on the convention wrongly, then they must come here and attack the constitutionality of the convention. You can't, that's the autocratic crisis that they have. You can't just jump the queue and say, I accept your convention, I'm leaving it intact. It says once you nominate from your party, you're fine. And then we go and vote. And I accept the constitutionality of that convention, because that's what you do when you acquiesce in it, when you're not challenging it. But I don't like its outcome. Courts are not for that. You can't accept the convention, embrace it, and then, as Mr. Makanis, the Greek surname, sorry. Mikalakis, yeah, said, you can't say, no, accept the convention. Not only do I accept it, but I only have moral problems with it, and so on and so on. Even if, for that matter, you had legal problems with it, then you must assail it. That's what Mr. Muela was saying. You can't, you have so many list of alternative remedies along the way. So that's the first problem they have. But the real problem on this Section 165 point is the following, Justice Park. It seeks through the back door, as Mr. Masuku was saying, to amend the Constitution and introduce a new qualification criterion, which the drafters of the Constitution did not do. You know, what we say to students is when you are interpreting the Constitution, the starting point is the Bill of Rights. If you make that mistake of not starting with the Bill of Rights, you 100% you're going to go wrong. Because the reason why those rights in Chapter 2, and Section 165 is not in Chapter 2, the reason why those rights in Chapter 2 are entrenched and elevated above all others is because everything else in life must be interpreted according to them, even the common law, legislation, regulations, rules of court, what have you, must be interpreted through the prism. That's what the court in the Constitutional Court said, through the prism of the Constitution. And fundamentally is the Bill of Rights. And that's the Justice Collis in a discussion with Mr. Masuku touched on this. Dr. Hlophe, like all of us, citizens of South Africa, has the right to hold public office. If you start there, you can't go wrong. He has the right to, the constitutionally entrenched right to hold public office. Public office means you are a member of, if you are a member of parliament, you are a member of parliament. That's it. How do we know this? We know it because in section 89(2) of the Constitution, there is a forfeiture clause which has been prescribed by the constitutional drafters in the case of a president who is impeached. And the drafters of the Constitution say in 89(2), it's uncanny. They say you can be impeached for this, that, and the other. Then they say anyone who has been removed from office, the office of the president, in terms of subsection 1A or 1B, that's misconduct or incompetence, may not receive any benefits of that office, and here's the catch, and may not serve in any public office. Right? So, the section 89(2) takes away your right as a citizen to hold public office because you are a president. Section 177 does not do that. The DA cannot do that. This court cannot do that. Nobody can do that except the people of South Africa if they want to change this book. And you can't say, no, the drafters of the Constitution forgot in section 177 to put a forfeiture clause. They must have thought about it and deliberately said, no, we will reserve this forfeiture clause for presidents. But if you are a public protector, as has happened, or a judge, as has happened, you can hold public office. And once you can hold public office, you can hold public office. And it must come with all its, everything that comes with it. So this court is being asked to do the most ridiculous thing, which is to fashion a constitutional amendment that introduces a forfeiture clause where the constitutional drafters decided they should not have one. You cannot do that. And that then takes us to your question, Justice Padko. So 165 as a whole is about the judiciary. Mr. Masuku was at pains to explain to us this morning that Dr. Hlophe is not a member of the judiciary anymore, and unless Mr. Masuku wins his case in the Constitutional Court and whatever happens to that. So that section is just being abused, well, not abused, misapplied. Let me not be harsh to them. It's being misapplied. They say it's not legislative measures to the designation. But now, this 165.4 says through legislative and other measures. So suddenly now it fits, but let's put that aside. Must assist and protect the courts to ensure the independence, impartiality, dignity, accessibility, and effectiveness of the court. What does that mean? It means, and it has been applied by our court, organs of state, it's like saying we expect more from you because you are organs of state, you are our family. Organs of state, for example, that thing is about contempt of court and those kinds of things. So if an organ of state is being told, you may not issue this tender, or you must withdraw it, unlike some of us might want to dodge that, but the organ of state is expected to assist the courts in their dignity and their effectiveness by implementing their outcomes and that kind of thing. And so you can't turn a section in the rest of the Constitution and want to elevate it as if it's a fundamental Chapter 2 right. It's not. In fact, Justice Madanga, in the case, I think it was New Nation.
Well, without interrupting you, Parliament is an organ of state.
Yeah.
Yeah. So why tend anything? Nothing is being tended. It's just being applied and referred to as a section that applies to Parliament.
No, Justice. I think maybe we're talking at cross purposes. Section. Okay. The case is called New Nation. It's fine. It's one of our cases. Because of time, I'll
yes, time is.
Yes. In New Nation, at paragraph 99 of New Nation, Madanga J says that, and he's talking about this very right, the right to hold public office, and that was repeated by Hlophe J in the other case, the more recent one. The right to hold office is sacrosanct in its own right. We all know the history of South Africa, people not having the right to vote and to stand for office and so on. And it says one of the mistakes you cannot make, I think in that case it was section 157, says you can't interpret section 157, one of the, 199. Yes, it was 157, thanks. He says, viewed with this background in mind, section 157.2 does not contradict section 19.3b, which is the one we're talking about, the right to hold public office. In that context, and that's what I'm saying, Justice, sorry, you know where I'm going with this. I'm saying section 165 cannot be interpreted to defeat the purposes of 19.3b. And it says, in that context, section 19, which is the primary source of people's political rights, continues to be the fundamental norm on them, right? Not section 157.2, which is tailor-made for municipal elections. So you can read there, not section 165.4, which is tailor-made for the judicial. I'm just cutting and pasting. The normative force of section 19 continues to apply in every instance where the Constitution has not specified a system of representation different to what section 19 requires. Therefore, and here's the punch, in the election of members of the National Assembly and provincial legislatures, the normative system the Bill of Rights itself creates in section 19 must apply. It must not be derailed or diverted by provisions specially created for municipalities under 157. And again, you can paste there. It must apply, it must not be derailed or diverted by provisions specially created for the judiciary and all those things. The sum total is very simple. A normal constitutional provision, which is not in the Bill of Rights, cannot be interpreted in such a way that it defeats the Bill of Rights, a provision of the Bill of Rights. So it can, section 165, you can interpret it as much as you like the whole day, but it can never be used to take away Dr. Hlophe's rights in 19.3b to stand for public office and then be treated like any other person. That's what it says. The starting point is always the Bill of Rights. And then you can go to all these other let me just wrap up.
Please, we have reached lunchtime.
Yes, thank you, Justice. I'll just go through. Oh, yes. Sorry, I'd asked Mr. Masuku to remind me of a point that he raised, which I wanted to develop. And again, it's really to accentuate the absurdity, and it goes to this section 19.3p point, by the way. Mr. Masuku thinks he's raising it tongue-in-cheek. It's not tongue-in-cheek. Mr. Dr. Hlophe is the leader of the opposition, as we speak, of the official opposition. In other countries, that would be, he's the shadow president of the country. That's how they do it. So it's not beyond the realms of possibility that tomorrow he may be voted the president of South Africa. Maybe after the Pala issue has been dealt with properly. But on a serious note, if that happens, which it may, then the reality will be that what the DA and all these people are saying is that he will take the power to appoint now. To appoint. Remember, they say in their papers, how can an impeached judge appoint? That's an exaggeration. The JC doesn't appoint anybody, by the way. The JC is an advisory body. Doesn't appoint anyone. The person who appoints is the president. So now he would be in a position where he appoints the Chief Justice. Chief Justice, you can nominate one if you are the president. I mean, it's just called a nomination, but you can just handpick whoever you want. Probably Mr. Masuku would be the Chief Justice. If Dr. Hlophe was the president. Yeah. But, so you now have the omnipotent power to appoint, not advise, appoint the entire judiciary, the Deputy Chief Justice, the President of the SCA, and everyone. Why? Because you qualify in terms of Section 47(3) of the 47 of the Constitution. The day you are an unrehabilitated, insolvent, or whatever, it will take you out. So, what kind of madness, for lack of if you excuse my language, for lack of a better word, would say somebody is in a position where he's one of the 400 people who could theoretically become the president of the country and appoint, but they do not qualify to be one of 6 people who are going to be part of an advisory body with 23 people. What is that? He could do it alone, sitting alone in Makambandlo.
Yes.
And on top of that, we know that we have now ministers who have been to prison for crimes. Some of them, and we have another minister who was a serious general in the SADF that murdered our people. And those people, nobody has said, these people, how can you have a person, and I don't want to go into the repentance story of Mr. Masuku, but how could you have a minister, a whole minister of our cabinet being, having that passed, whether you like it or not? And by the way, Justice, if I can make this point, our Constitution even tolerates a murderer. A murderer can go to jail for 20 years for murder, rape, child molestation, and the works. And then they come out, and then 5 years later, they can be a member of parliament and the president of this country. But no, not Dr. Hlophe, because what? Why? Because some racist cabal has decided that generals used to say. It cannot be. And if it's going to happen, they must go and campaign and win the votes and change the Constitution and put in Section 47 something that says not only the 5 years thing, but also impeached judges must be included. Fine. Then we'll have another debate. But do not ask our courts, do not denigrate. The Emperor of Abatembu was correct. If you denigrate these courts of ours, you will regret it, because the people of this country are not stupid.
Yes.
One day they will say this far and no more. And we cannot be ruled. We are ruled by people who have elected, and now when that fails, we go to some unelected people who are going to tell us how we should run the country. The Constitution, this is my last word, Justice.
Yes.
The Constitution of South Africa, the first 3 words in that Constitution say, we the people, not we the judges, not we the speaker, not we the DA, not we the racist, we the people of South Africa. Thank you.
Thank you, Mr. Court adjourns until 2 p.m. Mr. Turnbull.
May it please the court. May I report that I started on 2:05.
You have your allocated.
Thank you very much.
Yeah.
You heard the most extraordinary statement today from counsel for the official opposition, MK. What he said was that the rule of law is worthless, and if I can quote him, that we should throw it into the dustbin. So you have a litigant before you who says that the rule of law is worthless and you should throw it into the dustbin. Well, of course you will do no such thing. Section 1C of the Constitution says that the founding values of the Constitution include the supremacy of the Constitution and the rule of law. So it's not open to a litigant to urge you to throw the rule of law into the dustbin. And then you can understand that it is resentful that freedom under law is here in defense of the rule of law. That is its cause for which it has been constituted, is to defend the rule of law. And we submit with respect that it is ill behoves a litigant who says that you must throw the rule of law into the dustbin to be resentful about the fact that freedom under law is here to do what it was created to do, and that is to defend the rule of law.
Yes, it sounded like an extreme expression to an extent where one would have thought, is it a hyperbole maybe,
Well,
to try and make a point, but
I don't know what point one makes when you say you must throw the rule of law into the dustbin. And my learned friend mustn't interrupt me now. You can speak when I've done.
Mr. Mpofu,
Yes. Well, my lord, I just want to clarify because I'm now being distorted. I said the rule of law and I equated it to the apartheid rule of law. That must go to the dustbin. That's so I don't want to be misquoted by anyone.
all right, we'll allow you that.
Otherwise, it's yeah.
Yes,
May I turn to
And
the
not
issue?
deliberately as well.
thank you.
I beg your pardon?
Uh-huh.
Please,
I must not be
please.
misquoted deliberately.
Please, counsel,
by anybody.
please, counsel.
Anybody.
Let's hold the decorum. Let's hold the decorum.
May I go to the issue of remedy?
Yes.
Now, on that score, freedom under law is here with a freestanding application of the simplest kind for final relief. It affords the respondents the normal time required by the rules of court to respond, so they weren't in any way restricted in their responses by the time allowed to them. Having launched an application of the most ordinary kind, it is before you today entitled for its case to be adjudicated, and if it makes out a case, for an order to be made in its favor. We submit with respect that if a case is made for final relief, in other words, if it established its cause of action, then it is entitled to an order from this court to that effect. And we say so for three reasons. Firstly, Section 172(1)(a) of the Constitution says that when deciding a constitutional matter within its power, a court must declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency. And we emphasize a court must declare. And the Constitutional Court has held must to mean must. It did so, for instance, in Hlophe, as Hlophe Consolidated Investment Holdings v. Chief Executive Officer, South African Social Security Agency, 2014, Volume 1 SA, 604 CC, paragraph 25, where it said the following: once a ground of review under Padja has been established, there is no room for shying away from it. Section 172(1)(a) of the Constitution requires a decision to be declared unlawful. The consequences of the declaration of unlawfulness must then be dealt with in a just and equitable order under Section 172(1)(b). And the court reiterated that in the Nkandla judgment, that's EFF v. Speaker, National Assembly, 2016, Volume 3, SA 580 CC, paragraph 103. Said declaring law or conduct inconsistent with the Constitution and invalid is plainly an obligatory power vested in the court as borne out by the word must. Unlike the discretionary power to make a declaratory order in terms of Section 38 of the Constitution, this court has no choice but to make a declaratory order where Section 172(1)(a) applies. Section 172(1)(a) impels this court to pronounce on the inconsistency and invalidity, in this case, of the President's conduct and that of the National Assembly. That's the first reason. The second is that freedom under law as a litigant is entitled to an order in its favor. If it comes to court and it makes a case, then it is entitled as of right to an order to that effect, vindicating its claim. But in the third place, we submit with respect that it is also the right thing to do, that the appropriate manner in which a judicial function is to be performed in this case is to resolve the dispute before you, if you can, by a final determination today, rather than an interim order. Then one might say, well, what about the pending matter before the Constitutional Court, the Affli-Forum matter? Shouldn't the case be postponed pending the outcome of the Constitutional Court application? We submit with respect not, for the following reasons. Firstly, it would be an application of the duty imposed on the court by Section 172 and at common law to give a litigant final relief when it makes a case. Secondly, what happens if the Constitutional Court dismisses Affli-Forum's application and we come back to this court? What happens then? Do we re-argue the case? It just doesn't make sense for us to be required to come back again for reconsideration of our case if we have made a cause of action. But in the third place, what if the Constitutional Court takes on Affli-Forum's case? Now, with respect, the Constitutional Court has often made it clear how important it is for it, in the performance of its functions, to have the input of the lower courts, the High Court and the SCA, on matters that come before them. So no harm will be done by a judgment from this court, and on the contrary, you will know that you will deliver a judgment which the Constitutional Court has frequently made plain is useful to it in the performance of its function. So we submit with respect that if my client has made a case, then it is entitled to final relief, and that it would not be appropriate to postpone the case. If I could turn to a different topic, and that is the question of the facts of the manner in which the decision was taken in Parliament. My learned friend, Mr. Hlophe, said that somebody lied to you about the process. Well, I don't know whether he included me in that accusation, but what I would remind you of is that I based my submissions to you on the events in Parliament in large measure on the answering affidavit of MK deposed to by its leader, Mr. Zuma. And I invite you to look at his affidavit again, where he makes it absolutely clear that what happened in Parliament was in accordance with the convention that the majority parties endorsed the nomination of the EFF. In his affidavit, from page 06-25, paragraphs 60 to 62, 66, 141 and 142.
Sorry, you said paragraph?
Firstly, paragraphs 60 to 62, 66, 141 and 142. I won't read out all of them, but maybe if I could remind you just of 2.5 of them. Paragraph 61. It is common cause that in the Chief Whip's forum, all parties, including the DA, adopted an unwritten rule granting total and undiluted autonomy to political parties in the selection of their own representative. And then at 141, I admit that no political party represented in the National Assembly, including the DA, contradicted or challenged the established autonomy or prerogative rule or convention which provides that the decision of a nominating opposition party is binding on the National Assembly, nor did any party ever seek to review the said convention. And in the following paragraph, 142, he says, the statement of the ANC Chief Whip is absolutely correct. Now that statement is this, if I can just give you the reference, that statement is quoted by the Speaker at 05-29, paragraph 53. So you have spokespersons for the two majority parties. Both say that we adhere to the convention that the National Assembly endorses the nomination by the minority parties. So you were not lied to, you were quoted the evidence given by MK and supported by the ANC. And I turn to my learned friend who complains of feeling lonely in his submissions on the exclusive jurisdiction of the Constitutional Court, and I'll try my best to make him feel even more lonely. Under Section 167(4)(e), the Constitutional Court has exclusive jurisdiction to determine whether Parliament has failed to fulfill a constitutional obligation. That is what the area definition of exclusivity is. Has it failed to fulfill a constitutional obligation? Now, my learned friend assumes that the constitutional obligation we're talking about is the obligation under 178(1)(h). That's the duty to designate 6 people to the JSC. But it is not our case that the National Assembly has failed to fulfill that obligation. It has designated 6 people. So there's no contention that it has failed to fulfill 178(1)(h). The contention against it is that it has failed to make that designation in accordance with PAJA or in accordance with the rule of law, the legality principle in Section 1C. That is the contention. So the constitutional obligation that was violated here was the obligation under Section 3 of the Constitution, read with PAJA, or the obligation under Section 1C of the Constitution. But they are stock standard, generic standards which apply to the exercise of all public power. There's nothing exclusive about them. So the fallacy in the contention of my learned friend is that he starts from the wrong premise. We're not here to contend that Parliament failed to fulfill 178(1)H. We are here to contend that Parliament failed to adhere to PAJA and to Section 1C of the Constitution. And that distinction was made clear by the Constitutional Court in the case of Women's Legal Centre Trust, the President of the RSA, 2009, Volume 6, SA 94, Constitutional Court, paragraphs 15 to 24. And if I may just read a few extracts from it. Paragraph 15. Justice Cameron said, any exercise of the judicial function may cause tension with the other arms of government and trigger political contention. Hence, the mere fact that a matter is or may become politically fraught does not of itself mean that this court has jurisdiction to deal with it. That will resonate yesterday's argument. We said that when there is political sensitivity in the case, then it is one that falls under the constitutional, exclusive jurisdiction of the Constitutional Court. The Constitutional Court held that that is not so. Paragraph 16, Section 167(4)(e) itself contains a significant pointer. Its agent-specific focus. The provision means Parliament and the President and them alone. This court has recently observed that the constitutional duties in the provision are pointedly reserved for the actors in question. The wording suggests that the exclusive jurisdiction relates to obligations resting on these agents only, in contradiction to constitutional duties they may bear together with other agents. In other words, if it were a case of a breach of 178(1)H, that would have been in the exclusive jurisdiction of the court. But if it is a case for a breach of a generic obligation of the rules that govern the exercise of all public power, then it is not exclusive. 24. Women's Legal Centre submitted that, on the respondent's own account, the adjudication of the present dispute involved questions that relate to sensitive areas of separation of powers and would require a decision on crucial political questions. That's the argument made to you yesterday. It would therefore fall within 167(4)(e) and this court's exclusive jurisdiction. That was the argument made to it. But Justice Cameron then says, but as indicated earlier, all exercise of judicial power in some way affects the separation of powers and may involve the judicial determination of questions with political overtones. That is not enough for this court's exclusive competency to be engaged. For that reason, we submit that the Constitutional Court clearly does not have exclusive jurisdiction in this case. Then, my last submission. The entire address of my learned friend, Mr. Masuku, and a very large part of the address of my learned friend, Mr. Hlophe, submitted to you that Dr. Hlophe is competent to be a member of the Judicial Service Commission because there are no requirements for membership of that commission under Section to the section we're talking about, other than that he must be a member of Parliament. And so my learned friend Mr. Masuku addressed you at length on how his impeachment as a judge does not disqualify him. My learned friend Mr. Hlophe addressed the same topic. But His Lordship presiding interrupted my learned friend Mr. Masuku and said, "But aren't you straying from the debate before the court?" My learned friend submitted not. We submit with respect that that perspective is entirely misguided, that that is not the debate before court. We did not come here to persuade you that a judge who's been impeached is disqualified from being a member of the JSC. That might be a different debate for another day, but that is not our contention. Our contention did not look at him and submit that he is disqualified. What our case does is to look at the National Assembly and the manner in which it exercised its power of designation. So we look at it top down and not bottom up. And if you look at the manner in which it exercised its power and you test it against the standards to which all exercises of public power must conform, then you see that it was unlawfully exercised. The National Assembly, firstly, didn't exercise a discretion at all. That is already fatal, regardless of what one thinks of Dr. Hlophe. It secondly allowed itself to simply rubber-stamped the nominations made by MK. Another fatal flaw in itself. It thirdly failed to do what Section 165 requires it to do, and that is to promote the integrity and stature of the judiciary in making its appointments. It didn't even ask itself the question whether the nomination of Dr. Hlophe would satisfy its duties under Section 165. And then my learned friend, Mr. Duplessis, submitted to you that they also exercised that power irrationally and unreasonably. So, the entire perspective of our case is that top-down perspective. Our case is not against Dr. Hlophe. Our case is against the National Assembly. We say, you, National Assembly, failed to exercise your public power in the public interest. That is why we're here. And that is why we submit that the manner in which you went about this decision was unlawful. As a footnote to it, my learned friend argued yesterday that if this designation is unlawful, then the other 5 designations were also unlawful. Well, that might be, but there's only one designation before you, and the rule established by the SCA in Oudekraal and by the Constitutional Court in Curlin says that a decision, administrative decision, stands and is regarded as valid until reviewed and set aside. So the only decision which has been challenged before you is the one to designate Dr. Hlophe. The other decisions are not under challenge, and under the Curlin rule are regarded as valid and binding until reviewed and set aside. So that is not your concern, because that is not before you. I thank you for your indulgence.
Thank you, Mr. Chengo.
Thank you, my Lord. I'll be doing the reply on behalf of the Democratic Alliance.
Thank you.
Thank you.
Sorry, if I may request your indulgence, Mr. Bishop has a broken foot. Could he address you while sitting? Unless he wishes to start.
Judge, I'm going to try and stand and see how it goes. But if it gets too painful, I might ask the court
I'll
to
hold him up.
That's not a metaphor for full supporting the DA. We have separate cases. Lord, I'd like to begin with what we submit this case is not about. And I'm going to pick up from where Mr. Trengove ended, which is to say, just as Full's case is not about whether the impeachment of Dr. Hlophe was good or bad, lawful or unlawful, the DA's case is the same. Whether that impeachment was a good decision or a lawful decision is irrelevant to our case. It's irrelevant to our argument of mistake of law, it's irrelevant to our rationality claim, and it's irrelevant to our Section 1654 claim. So it doesn't matter. The arguments you heard from Mr. Masuku this morning do not affect. It may be that in the future Dr. Hlophe wins a challenge to that decision. It's irrelevant to the case we brought. It's the question of whether Dr. Hlophe has repented or not repented is also irrelevant to the DA's case. We don't rely on that. We rely on the fact of his impeachment, which is not disputed. The second thing this case is not about is whether Dr. Hlophe is entitled to be a member of Parliament. Again, you heard a lot from Mr. Mpofu and Mr. Masuku about this. Section 19 was called in aid to say what the DA is trying to do here is to interfere with Dr. Hlophe's right to hold public office. This case is not about whether Dr. Hlophe can be an MP. We accept he is an MP. And for the purposes of this case, we don't dispute that. For the same reason, it's not about amending the Constitution. That is an argument advanced by Mr. Mpofu, that effectively what the DA is asking this court to do is to amend the Constitution by imposing restrictions on impeached judges that aren't there expressly. But that is not at all what we're doing. All we're asking the court to do is apply trite, well-worn principles of legality. That a public body must exercise a power given to it itself, and that it must act rationally, and that it must comply with the Constitution. That doesn't require constitutional amendment for this court to apply those principles. Finally, this case has got nothing to do with the privilege of members of Parliament, an argument you heard from Mr. Masuku. The privilege of MPs is not affected. They're free to say whatever they like in Parliament. That's what the privilege gives them, the privilege to speak without threat of civil or criminal punishment for what they say in Parliament. It also doesn't affect the privilege of the National Assembly. We're not saying the National Assembly cannot regulate its own process. We're saying the National Assembly must comply with the law and with the Constitution, which, as I'll get to later, the Constitutional Court has said probably close to a dozen times. The second topic I want to address is the composition of the JSC. And this matters for, first I'm going to address why we submit that the way the JSC is composed matters for assessing the merits of this case. And secondly, I want to address an argument that was made that if the DA is granted its interdict and Dr. Hlophe is prevented from sitting on the JSC in October, that will prevent the JSC from acting because it won't have all its members present. So I want to address that argument. So the first, we heard a lot, and rightly so, about the way in which the JSC is constituted, that it has a diverse representation of judges, lawyers, academics, politicians, and that that's part of what gives it its strength. And we agree with that. But I also want to refer the court to authority that the way the JSC is constituted is also vital to ensuring its credibility and its ability to protect the integrity of the judiciary. My learned friends for Full yesterday referred you to the passage from the Helen Suzman Foundation case that people designated to the JSC must be suitably qualified. I want to refer you to the case of Hlophe versus Judicial Services Commission. It's the review case. And at paragraph 27, this is what the full court said. The JSC was established and its composition determined by section 178 with the aim of regulating judicial affairs and ensuring the integrity of the judiciary. And then it says at paragraph 47, the substance of section 178 is premised on the recognition that the JSC must enjoy credibility. Moreover, credibility with a nation whose social order is that of a constitutional democracy. And finally, at paragraph 50, if the JSC is to choose persons who can enjoy public credibility as fit for purpose as judges, the JSE had to be constructed to meet democratic norms so that it could make a claim for its own public credibility in a democratic society. So,
what citation was that?
so it's the citation is 2022 3 All SA 87, a decision of the Johannesburg High Court. It's Hlophe versus JSC.
Yes, and the paragraphs you
it was 27, 47, and 50.
Thank you.
So what the court is saying is that in order for the JSC to do its job of selecting judges that have credibility, it must have credibility. And so that goes obviously to the general way in which it's constituted, a mix of people from different backgrounds. But we submit also here, to this purpose, when those people who have the power to designate, whether it's the president, the judge's president, the universities, the bar, or parliament, when they are making that choice, they also have to make the choice with that purpose in mind, that the JSC must have public credibility, because otherwise it cannot do its job. And we accept that ordinarily an MP, all things being equal, will be able to satisfy that requirement. But there will be circumstances when MP serving on the JSC will undermine public credibility. And when that is the case, that person cannot be designated to the JSC. So I then want to deal with the argument that was made that what the interim interdict that the DA and Corruption Watch are asking for would prevent Dr. Hlophe from sitting on the JSC until Part B or the Constitutional Court proceedings are resolved. So that may be one sitting, and maybe two sittings, and maybe three sittings. But the argument was made, because the Constitution says there must be 6 members from the National Assembly, if Dr. Hlophe is not there, the JSC will not be able to act. So for that reason, the interdict is inappropriate. And there's 2 answers to that. The first answer is that the JSC can act when some of the listed members are not present, if they are absent for reasonable and adequate justifications. And the authority for that is the same judgment I referred you to earlier, the Hlophe judgment. And from paragraphs 38 to 44, the court deals with 2 earlier SCA cases dealing with the position of whether the Western Cape Premier had to be part of the JSC, and dealing with a challenge by the Cape Bar to the non-appointment of certain judges. It refers to those cases which dealt with this issue. And from those cases, it draws that principle in paragraph 40, that as long as there are reasonable and adequate reasons for the absence, the JSC can continue. So you can imagine if the JSC, and JSC meetings are called 6 months in advance, they're massive occasions, they last for a week or 2 weeks. If on the way to the JSC meeting, a member unfortunately had an accident and broke their leg and was unable to attend, that wouldn't mean that the JSC cannot sit, because there would be a reasonable and adequate justification for that member's absence, and the JSC would be able to continue. And that's what the full court found in Hlophe. And we would submit that an interdict from this court is plainly a justifiable reason. But the second answer is that the National Assembly is free to designate a new person to fill that 6th spot that's currently occupied by Dr. Hlophe. And we make that allegation. It's in the papers, in the founding affidavit, paragraph 65, page 1-26. And it's not denied by the Speaker that the National Assembly would be in a position to designate a new MP to take over from Dr. Hlophe. So there's 2 easy answers. The interdict would not prevent the JSC from sitting at all, whether the NA acted or not, but the NA can act. I then want to turn to the merits of the review. Now, of course, my case is an interim interdict case, but the prospects of success are relevant. We submit both at the prima facie right level and the balance of convenience level. And there are a few arguments that I want to counter that were made by my learned friends. The first is an argument made particularly by Mr. Masuku that all members of Parliament are equal. So if you're an MP, you must be able to sit on the JSC, and nothing else should be required or can be required. And the way we read the Constitution is being an MP is a minimum qualification. You must be an MP in order to be designated by the National Assembly. So if you're not an MP, the NA cannot designate you. But that's not the limits of the requirements the Constitution imposes on how the National Assembly acts. So our case is about how the National Assembly exercises its power to designate. And designate means to choose. You must exercise a discretion. Amongst all 400 MPs, you must choose which ones you're going to send as your representatives to the JSC. And the National Assembly cannot act randomly. It cannot hold a lottery where it pulls 6 names, 3 names from the opposition and 3 names from the non-opposition out of hats. It cannot sell the positions to the highest bidder. And it cannot designate without ever exercising a discretion, and instead leave it to the political parties to do the work that the Constitution assigns to the National Assembly. So in this sense, the case is exactly like the Similani case. There too, Advocate Similani met the minimum qualifications to be the National Director of Public Prosecutions in the NPA Act. He had the necessary legal qualifications. But that wasn't enough. The President also had to act rationally when he took the decision to appoint Mr. Similani. And the same is so here. There was also a submission made that there's no situation in which limits are placed on members of Parliament serving on committees of the National Assembly. And we point out in our heads of argument that that's not true. Under the Intelligence Oversight Act, which creates the Joint Standing Committee on Intelligence, it creates strict requirements for which MPs can serve on that committee. You have to obtain a security clearance, you have to be approved by a committee made up of the chairperson of the NCOP, the Speaker, and the President, and there's a whole process for how you get on that committee. And it's because of the particular work that that committee does. That's an internal committee, it's a parliamentary committee. But because it's doing intelligence work, it requires that we say, even though you're an MP, if you cannot get security clearance, you cannot be on that committee because you will have access to top secret information. And so we're limiting the pool of people who can be on it. And we submit, in a similar way, that's the case here. Most MPs, yes, they can be on the JSC if the National Assembly takes a proper decision to designate them. But if that MP, because in this case they're impeached as a judge, if their presence on the JSC would undermine the JSC's credibility, making it impossible for it to do its work, then that person cannot serve on the JSC. An argument was made that because the Constitution imposes consequences for a president who is impeached in Section 89(2) and doesn't say anything for judges, therefore it must be interpreted to mean that there are no consequences for an impeached judge. And we submit, firstly, the argument doesn't really answer the attack, because the attack is that when you designate, you must act lawfully and rationally. So it's not an answer to the attack. But in any event, merely because the Constitution imposes certain restrictions on the President doesn't mean similar restrictions cannot be imposed through other principles of the Constitution, principle of legality, and Section 1654 of the Constitution. Third, my learned friend, Mr. Hlophe, made the argument, he emphasized the word consider, and he made the argument that these issues, the impeachment of Dr. Hlophe, his suitability, were considered by the NA because they were raised by the various members who debated the issue, and therefore they were considered. That's not our argument, that they failed to consider them in that sense. Our argument is that they didn't consider them because we know from the transcript that particularly the African National Congress said, even though you said all these things about him being impeached, they're irrelevant because we must simply accept the nomination. So that's why they weren't considered. Even they were mentioned. Everybody's aware that Dr. Hlophe had been impeached, but they weren't considered because they said we're bound by the practice, and we don't have the power to refuse to designate Dr. Hlophe. So that's why they weren't considered. Finally, on the merits, there was an argument that the DA was required to attack the practice or convention of accepting parties' nominations. And because we haven't attacked that practice or convention, we cannot complain that it was followed. But that's wrong for two very simple reasons that come from the National Assembly's rules. Rule number 5 says no convention or practice may limit or inhibit any provision of these rules or any order of the House. And you also need to read Rule 9.2, 9 sub 2. Conventions and practices must be consistent with the provisions of the Constitution. These rules, orders of the House, rulings and directives, and guidelines of the Rules Committee. So the conventions and practices are what fills the gap where there's nothing else. But here we have the Constitution. The Constitution says you must exercise the power yourself and not delegate it. The Constitution says you must act rationally, and the Constitution says you must uphold the integrity of the judiciary. So we don't have to challenge the conventions and practices, because on the National Assembly's own rules, rightly so, you could never say a convention overrode the Constitution, but the rules themselves recognize that. I next want to turn to the requirements for interim relief. And there's 4 arguments I need to address here. The first is that granting the relief would violate the National Assembly's authority. There's 2 answers to this. The first is that the National Assembly hasn't opposed the application. So when we cited the Speaker, we don't just cite the Speaker as the Speaker, we cite the Speaker as a representative of the National Assembly. The Speaker is here as the National Assembly. One cannot cite the National Assembly in papers, you always cite the Speaker. So the National Assembly has not opposed this. So in those circumstances, it's difficult to understand how it would violate the National Assembly's authority. And the National Assembly says, we have no difficulty with this order that the DA is seeking. But the second is that the Constitution permits invasion when it is justified. And the authority for that is many cases, but particularly the decision in Doctors for Life at paragraph 38. So in paragraph 37 of Doctors for Life, the court talks about the importance of courts not interfering with parliamentary processes. But then it says in 38, but under our constitutional democracy, the Constitution is the supreme law. It is binding on all branches of government and no less on Parliament. When it exercises its legislative authority, Parliament must act in accordance with and within the limits of the Constitution. And the supremacy of the Constitution requires that the obligations imposed by it must be fulfilled. Courts are required by the Constitution to ensure that all branches of government act within the law. So where Parliament has not acted within the law, it is permissible to grant this type of relief. The second issue on the requirements for interim relief is about OTA. And the argument was made, well, the DA didn't plead the requirements of OTA, and that should be the end of the case. But of course, as the bench knows, one pleads facts, one doesn't plead law. And a useful authority in that is VENMOP 275. The citation is 2016, Volume 1, SA 78, and it's a decision of the Johannesburg High Court. And what the judge there is dealing with, the sort of common refrain you see at the beginning of every affidavit, that legal submissions are made on the advice of my legal representatives. You see that at the beginning of every affidavit. And he says he has problems with this. He says, however impressive this might be to a lay client in justifying a legal representative's fee for voluminous affidavits, I find this practice disturbing in at least 4 respects. First, by their very nature, these submissions have neither evidential content nor probative value. As argumentative, they have no place in affidavits. It is not for nothing that Rule 6 of one of the Uniform Rules of Court provides for an application to be supported by an affidavit as to the facts. He says, secondly, the argumentative submissions that follow expressly admitted hearsay and as such inadmissible. Thirdly, the submissions amount to legal opinions on matters upon which the court is required to decide. So the OTA test is that this is the clearest of cases. Various other words are used. But that's not a fact. That's an opinion you draw from the facts. Is this the clearest of cases? It's not so just because a deponent says this is the clearest of cases. The question is, have they pleaded facts that show this is the clearest of cases? So I, of course, accept that DA is bound to the facts that are in the founding affidavit. But the fact that it didn't in the affidavit say, these facts mean this is the clearest of cases, there's no reason to dismiss the application.
And does Hlophe or rather OTA create new requirements other than in Hlophe?
In our view, it doesn't create a new requirement. What it says is when the court is dealing with interdicts, of organs of state or the exercise of public power, it must be particularly careful when it grants it. So when it's weighing the balance of convenience, it's really, it comes in at the balance of convenience stage, that the balance of convenience will only favor the grant of that interdict against an organ of state in the clearest of cases because of the separations of power harm. But I've never understood it as a new, separate, self-standing requirement.
It's an elaboration or
Yes.
clarification.
Yes, it's about how one of those requirements applies in a particular subcategory of cases.
Yeah.
We come home whether OTA applies or not, but it's debatable whether it does for two reasons. Firstly, our interdict is against Dr. Hlophe, not against the National Assembly, and secondly, the National Assembly and the JSC have abided. The next point on interim relief is about the prima facie right. And the argument that was made here is that prospects of success in a review cannot establish a prima facie right. We've dealt with this in paragraph 43 of our heads, that there's subsequent constitutional court authority that qualifies what Moseneke DCJ said in paragraph 50 of OTA. It's the South African Informal Traders case and the Vaal River case. And what they say in Informal Traders at paragraph 25 is, a prima facie right may be established by demonstrating prospects of success in the review. Could not be clearer. But in any event, we identify other rights. We identify our right to an effective remedy, and we refer the court in paragraph 44.1 to the authorities that say that is, that can be a prima facie right for the purpose of interim relief. And we rely on the right to an independent and impartial judiciary. And we refer in paragraph 44.2 to the sources of that right. Section 34 of the Constitution, Section 1654 of the Constitution. And we didn't have to plead that. We pleaded the right expressly in the founding affidavit. We don't have to explain the legal source for the right that we're pleading. The opponents don't have to plead case law when they're asserting where the right comes from. That is legal argument, properly in heads. So there clearly is a prima facie right. On the question of alternative remedies, the argument was made that in their answering affidavit, MK listed a variety of alternative remedies. We didn't deal with it in reply, and therefore they must be accepted that there are alternative remedies. We do deal with it in the reply. It's paragraph 46, case lines 08-17, where we say we deny any of these are alternative remedies. And they're obviously not when you look at them, because the one is to amend the Constitution. But an alternative remedy for the purpose of interim relief cannot be, well, you could change the law. Yes, that's always the case. We could change the law, and then maybe we wouldn't need interim relief. But that's not a reason, that's not an alternative remedy. An alternative remedy is an alternative remedy under the existing law, where I could go to court. Could I get damages? Could I get some other type of legal remedy that would avoid the need for an interdict? And as Justice Collis pointed out, these could never be obtained before the 7th of October. You could never amend the Constitution before the 7th of October. You almost certainly couldn't amend the NA rules before the 7th of October. Those processes would take far longer. There's also an argument that, well, our alternative remedy is we should have interdicted Parliament or MK. But, I mean, there's three parties, Parliament, Hlophe, and MK. We come to court and we ask for an interdict against Hlophe. And then the argument is, well, you could have asked for an interdict against the MK. But the answer then, if you'd asked for an interdict against MK, is, well, you could have asked for an interdict against Hlophe. It doesn't get you anywhere. We've asked for an interdict against Hlophe. Saying we could have also got an interdict against somebody else, there's no reason not to grant it against Dr. Hlophe. And finally, on the final alternative remedy proposed is that we could have sent a letter of demand. In our replying affidavit at paragraph 46.2, we invite Dr. Hlophe to concede to the relief and agree not to attend the JSC sittings in 7th of October and to treat the request in the replying affidavit as a letter of demand. We haven't yet received a response to that. Lord, I was going to deal with this issue of the abuse of process, but I was largely going to deal with what Mr. Trengo began his address with about the rule of law. So I'm not going to repeat what he said, but just to emphasize the fundamental importance of the rule of law. and it's not something that can be discarded. I then want to, so my learned friends, Mr. Hlophe, didn't deal with the issue of standing, which is raised in their heads quite extensively. I don't want to deal with it in any detail, but can I just give the court one reference on the standing issue? And the case is Democratic Alliance versus Acting National Director of Public Prosecutions. It's one of the first of the so-called spy tapes cases. It's 2012, Volume 3, SA 486, SCA, in which the Justice Navsa for the Supreme Court of Appeal overturned a decision of the High Court saying that the Democratic Alliance lacked locus standi to review a decision to drop charges against then President Zuma. And it said the Democratic Alliance is entitled to act in the public interest, supporting the rule of law, because that's one of its. And exactly the same applies here. If I can then turn to the issue of jurisdiction, and just to outline the DA's position up front, we say that the Court does not have exclusive jurisdiction for Part B. This court has jurisdiction for Part B. But even if we're wrong about that, even if the Constitutional Court has exclusive jurisdiction for Part B, this court still has jurisdiction to grant the Part A relief. And it's not necessary to decide the issue of exclusive jurisdiction in order to grant the interim relief. On the first question of whether for the Part B relief and for Full's case, for final relief, the Constitutional Court has exclusive jurisdiction, I endorse what Mr. Trengove said, but I just want to refer the court to one other case that may make Mr. Katz feel even lonelier, because not only does everybody here disagree with him, Mr. Katz 2 years ago disagrees with Mr. Katz today. So in the African Transformation Movement case, which Mr. Katz referred to quite rightly, he drew to this court's attention, because in that case the ATM, who's also his client today, took the opposite approach. It said that, and the speaker in that case said that the issue was in the exclusive jurisdiction, and Mr. Katz argued that it was not. And this is what the court said. It's at paragraphs 22 and 23. It's in our bundle. This passage starts at page 243. The judge said, "In my judgment, the cause for complaint by the applicant is procedural in nature. It is abundantly clear that the applicant's case is not that Parliament or the President has failed to fulfill a constitutional obligation, as envisaged in section 1674E. It is the procedure leading to that end that is impugned, a means to an end. To suggest otherwise would be tantamount to putting the cart before the horse." Then says, it could hardly be suggested that when the Speaker commits an alleged irregularity, as was argued by Mr. Katz, in deciding how Parliament is to conduct proceedings in a motion of no confidence in the President, that such a decision amounts to Parliament having failed to fulfill a constitutional obligation. It cannot be suggested that when the Speaker acts irrationally or in an unreasonable manner in the exercise of her discretion in deciding on the voting procedures, such decision amounts to Parliament having failed to fulfill its constitutional obligation. And so exactly the same is here. Same is true here. Although it's not the Speaker, it's the National Assembly, our case is that they failed to exercise their discretion and they acted irrationally. That's the case we brought. It may be that there's another case that could have been brought that says that the designation of Dr. Hlophe is a failure to fulfill the obligation in section 178(1)H. That's a case that AfriForum makes in the Constitutional Court, but it's never been our case. And our case is in this court's jurisdiction. Finally, on the question of whether this court has jurisdiction to consider the interim relief, I understood Mr. Katz to largely concede that, to say that, yes, this court probably does have jurisdiction. Even if the Court has jurisdiction for Part B, this court still has Part A jurisdiction. But he said it would only be appropriate to grant it in the circumstances set out in paragraph 32 of the UDM case. So just a few submissions on that. We submit that it's very different. The UDM case was about suspending the operation of a constitutional amendment. What we're dealing with here is something far less drastic. It's merely interdicting one person from serving on the JSC. So we're not sure that those strict requirements apply. But even if they do, even if the strict requirements in paragraph 32 of UDM apply, they're met in this case for all the reasons that are given in the founding affidavit. The final point, just to emphasize, is if this court wants to grant Ful's final relief, it must make a final determination on the exclusive jurisdiction question, because it cannot grant the final relief without deciding that it has jurisdiction. For this court to grant the interim relief, it does not have to decide that question. It can merely decide that whether or not Part B is in the exclusive jurisdiction of the Con Court, it would have jurisdiction for Part A. So even if Part B is an exclusive jurisdiction, it has jurisdiction for Part A. So it can leave that issue undecided if it wishes to. And that leads me to the final topic I wish to address, which is the question of should the court grant interim relief or final relief or both? How should it deal with the fact that it has applications for both before it? Firstly, to clear up some confusion about the order that we want. There was some paper moving around and uncertainty about the order. We uploaded the correct order exactly as we wanted onto case lines. And so it's in substance identical to the order sought in the notice of motion. The only difference is to accommodate the new constitutional court proceedings, which didn't exist when we launched the application. And so what it says is the interim relief would be pending either the determination of Part B in this court or the determination of either the DA full corruption watch application or the AFRI-Forum application by the Constitutional Court. Because obviously once either of those applications are determined on the merits, the interim relief should fall away. And so we're just trying to accommodate what happened subsequent to the launching of the application.
But are there two Constitutional Court application numbers?
Yes. Initially, the paper we gave you only has one.
Well,
I think
it refers to CC2253/24 and or case CC2253 of 24, exactly the same.
the new one we've uploaded on case lines has got different ones. I think it's
223 or something.
It's 222 is the AFRI-Forum one, 222 is the AFRI-Forum one, and 253 is the joint application by the three applicants here.
Where is it uploaded? Just give us a close reference, please.
So,
Where on case lines is it uploaded?
I'll get it in a second, the section lady, I apologize. So that's the interim relief that we want, and we want our interim relief. We're agnostic about whether you also grant full their final relief or not, as long as we get our interim relief. So the case lines reference, my lady, is 21-1. And my leader, Mr. Jamie, referred you yesterday to the ZEP case as an example where you can grant both the final and the interim relief. But what this court should not do, we submit, is to grant the final relief and not grant the interim relief. Just as Full has come with an application, the DA has come with an application. The DA came to court before Full did. We were the first applicant to launch our litigation. And we're entitled to determination of our application. And we submit there is a reason why interim relief is important, whether final relief is also granted or not, which is we want to protect the October interviews for the JSC. And if interim relief is granted and there is an appeal on that order, the appeal will not suspend the operation of the order. If only final relief is granted and there is an appeal of that final order, the appeal will suspend the operation of the order and will defeat the purpose for which the DA came to court, which is to prevent Dr. Hlophe going to the October interviews.
Unless the argument is that the kind of relief then is actually final relief.
Well, Lord,
What Mr. Masuku said.
Lord, that may be a debate that has to be had later, but I think it's plainly interim relief.
I follow what you say, but
yes.
There's a difference of opinion.
There may be, and depending on what this court says in its judgment, it may be a dispute that will need to be resolved. But we still submit that the interim relief, if this court makes it clear that its relief is interim in nature and not final in effect, then there will be no debate. And how Section 18 of the Superior Courts Act operates will be clear, and there won't be another need to. I was recently involved in a matter where exactly that had to happen. Apparently interim relief was granted, and the parties then had to go back to court to fight about whether it was interim or final. So I prefer to avoid that. So we submit that ideally what this court can do is grant both. If the court's not inclined to grant both, we submit that it has an option to grant the interim relief, but not at this point to decide Full's application for final relief. So I accept completely what Mr. Trengove submitted to this court, which is they brought an application, and the application must be decided. But this court can decide when it determines the application. It has the power to hold a decision in abeyance, to reserve judgment, pending the outcome of other litigation. And if I can give the court the references for that proposition. The first is the Masuku case. It's 2022, Volume 4, SA 1, CC, and it's at paragraph 133. What happened there is the Masuku case was about hate speech. And the case was heard, and then shortly after, the Constitutional Court heard the case of Malani, which was a challenge to the constitutionality of Section 10 of the Equality Act. And the court said, I'm going to hold in abeyance my judgment in Masuku until I've decided Malani, because Masuku must be decided on the basis of the outcome of the challenge to Section 10 of the Equality Act. So it says, we held it in abeyance. And you'll see 3 years passes between the hearing and the judgment. The second case is Mokone versus Tassos Properties, 2017, Volume 5, SA 456, CC, at paragraphs 67 and 68. So what happened there briefly is there were 2 appeals before the Constitutional Court. The one was an appeal by a lessee about whether they had a right of preemption to buy the property they were leasing. The second was an eviction, an appeal against a grant of an eviction from the same property. But what the court did is it upheld the preemption appeal and sent it back to the High Court because only part of it had come up on appeal. There were still other parts of the action that had to be determined. So it upheld the one appeal and then said, I'm holding the other appeal in abeyance until the determination of that outcome in the High Court. And the court expressly said it has the power to do so. It quotes Section 173 of the Constitution and says, put simply, this says, the mentioned courts may regulate their own process, taking into account the interests of justice. I will say nothing about equity, but based on this, I do not see why proceedings may not be stayed on grounds dictated by interests of justice. Whatever the import of what was said by courts previously may be, the Constitution lays down its own test, and it has everything to do with the interests of justice. In this context, the idea of interests of justice is quite wide. I will not attempt to delineate what it encompasses. Suffice to say, what justice requires will depend on the circumstances of each case. So this is a very similar situation where the court may take the view, and I'm not advocating for it. All I'm saying is don't refuse to grant our interim relief. One option open to the court is to grant the interim relief and then say full application is held in abeyance to be determined together with Part B of the DA and the Corruption Watch applications, or held in abeyance pending the outcome of the Constitutional Court proceedings. This court has the power to do that.
But their argument is that they've argued it already.
They're entitled to a judgment. They're not entitled to a judgment today.
Yeah, but that's what they're saying.
Yes,
They've
and
argued the matter already. They don't come back on a different day.
Yes.
Come and argue the very same thing they've argued.
But that was the case in Masuku, and that was the case in Mokone. The cases were argued, and they said even though your appeal has been argued, we're holding it in abeyance until the outcome of other litigation, because it would not be in the interest of justice to decide this case until that case has been decided. So this court has the power to do that. Finally, just 2 very quick submissions on costs. The first was a submission that Dr. Hlophe should get costs even if he loses. I think the submission was primarily addressed at freedom under law and certain allegations that were made by the opponent to their affidavit. If one looks at the DA's papers, there are not similar scurrilous allegations about Dr. Hlophe in those papers. What's said is factual, he was impeached, and so that type of submission doesn't apply to the DA. The second submission is just that BioWatch is irrelevant to costs in this case. Everybody before you is a private party, except the National Assembly who is abiding, and the applicants have all agreed not to seek costs against the National Assembly. Everybody else, the DA, Corruption Watch Full, Dr. Hlophe, and MK are all private parties. And so the traditional BioWatch rule that often comes into constitutional litigation doesn't apply here. And we persist with our request for costs on a punitive scale against Dr. Hlophe and MK. Those are my submissions.
Thank you, Mr. Bishop.
Lord, Mr. Bishop asked if he could steal some of my time, and I graciously accepted that proposition because I'll be quite short. I've got 6 matters to deal with in reply briefly. The first 3 are more procedural and the last 3 are more substantive. So just on the question of remedy, we haven't uploaded a draft order, but we think that the proposition or the proposal made by the DA is a good one, that the interim relief, if it were to be granted, should be pending either the Constitutional Court decision in those 2 applications or Part B in this one. We'll upload a similar order when we're done, and we'll make sure that your registrars have it. The second topic and the third topic are related, and it's the question of abuse and the question of costs. The argument on abuse is it's wide-ranging. The attack is to say we've come, I think they said we hunt in packs, we've come in separate applications and wasted their time and money. But what I want to say is what one should really look at first is the question of standing. Corruption Watch's standing was disputed. The Corruption Watch went to great effort to explain why it's here. Ms. Maharaj-Pillay gave extensive submissions yesterday about it. And this wasn't addressed, as far as we could see today, about Corruption Watch at all. We heard about how full and the DA are worse than us, the DA because it's a political party and full because of the history. But we weren't told why our submissions on standing on Corruption Watch were wrong. We've also explained why we came in a separate application. It's in the replying affidavit. I don't need to take the court there, but just a note. It's at bundle 10, page 24. And what we really say is that we can't go with the DA because we aren't a political party, we're an NGO. And we say we can't go with full because we think interim relief is the way to go. That's the way we approach the case. Hence we brought our own case. And we also say we aren't an amicus because, in a sense, we are partisan because we want relief. We aren't just here to assist the court. We are an applicant. If we'd come as an amicus and made the point, we would no doubtedly have been told we are partisan and you shouldn't have come as an amicus. What's not addressed is that all the respondents had a full opportunity to address our papers and did so. They filed consolidated affidavits, the 2 interim application matters, which are lengthy and deal with the applications for interim relief. So there really isn't a question of prejudice. So what we have left is really scandalous allegations about who Corruption Watch is and who funds it, etc. But these are comprehensively addressed in the replying affidavit. And we didn't hear anything today to dislodge those cogent explanations. As to costs, I mean, we don't care about costs, we hear about principle. If Corruption Watch wins, we leave that issue in the court's discretion. It's to do with costs. But if Corruption Watch loses for whatever reason, we say this. There were many unfounded allegations made against our client. In answering affidavits, they were then repeated in heads of argument, and they were repeated today. And we say that if Corruption Watch loses the application for interim relief, those unfounded allegations would factor into the court's determination of a costs order, and that the court wouldn't grant costs in favour of the respondents who made those allegations against our client.
Yes.
The next topic is just about alternative remedies. We were told today that Corruption Watch didn't address it. Corruption Watch addressed it. In paragraph 69 of the replying affidavit, we address it in full. That's at case lines page 10, stroke 21. My last 2 topics are a bit more substantive. The first one is about the right we assert, and the second one is the question of harm. So on the question of right, we've heard a lot about the outer test, and the outer test apparently now gives us 8 requirements for an interim interdict. But what paragraph 45 of outer says, the Deputy Chief Justice Moseneki says, it's unnecessary to fashion a new test for the grant of an interim interdict. Of course, what he says, though, is that when you're doing, Mr. Bishop made the point, when you're asking to restrain public power, there are further considerations that play a role. Clearest of cases, the balance of convenience because of separation of powers. But the court didn't go out and invent an entirely new test. It modified and adapted the old law that's been around forever. So the question is, what did we plead? And you were taken in the MK party's argument to one part of the founding affidavit, the heading about a prima facie right. And it's correct. Under that heading, we say we assert the right to review. But that's not the entire founding affidavit. If one turns over the page, we don't need to go there, but it's page 0331, paragraphs 94 and 95. Corruption Watch pleads what it says will be irreparably harmed in the interim. And it refers back to earlier parts in the founding affidavit where what is said is what I said to the court yesterday. What will be irreparably harmed is the independent, effective judiciary. Now we repeat this in the replying affidavit. And again, we were told that Corruption Watch did not respond to paragraph 164 of MK's answering affidavit. But that's incorrect, because it's exactly what we responded to, and we referred to para 164. So that starts at paragraph 55 of the reply at 10:17. But the specific point where we bring it together to make it clear about what rights are being affected is at 10:20 at paragraph 65. Justice Collis said, what about section 34 earlier? And that's what I mentioned yesterday. It's not in the affidavits. I'm not going to say it is. But we've heard about what law needs to be pleaded and where the facts need to be pleaded. But the point I made yesterday was that the corollary of an independent judiciary that must be given effect to and protected by organs of state in section 165 is the section 34 right. And that was my submission. My last topic, and I won't be long, is the question of harm. And what we heard yesterday and today from Mr. Masuku, Mr. Masuku and Mr. Katz yesterday, but from Mr. Masuku and Mr. Katz, was that the past is irrelevant. They both said the fact of the impeachment is irrelevant. And our proposition is that this isn't actually the past. This is right now. Dr. Hlophe was removed for conduct that happened a long time ago, 2008. I mean, I'm quite young. I was still in high school in 2008, if that means anything to anyone, before I even entered law school. But when was he removed? This year, in February. This isn't the past, it's the present. And again, just to draw us back to what actually happened, Ms. Maharaj Pillay made this point yesterday. This isn't examples about other people, Mr. Mpofu, my learned friend, spoke about who gets convicted and sent to jail for 20 years can become an MP. That's not what we're speaking about. Justice Hlophe was found guilty of attempting to influence constitutional court judges to find in favor of Mr. Zuma. Something Ms. Maharaj Pillay said yesterday was that this first thing Dr. Hlophe does when he's removed as a judge is join Mr. Zuma's political party. No one's denied that or addressed it. And why this is still today relevant is because before this court, and in an argument that was made today, Dr. Hlophe still refuses to appreciate the gravity of his misconduct. and the impact that this can have on the independence and the perception of the independence of the judiciary. And we say that this demonstrates the undoubted appreciation of serious harm that Corruption Watch has proven and entitles us to interim relief. Those are our submissions.
Yes. Thank you, Mr. DP. Well, that brings us to the tail end of our proceedings, and it remains for us to thank all participants, in particular counsel, in their extensive submissions and heads of argument, and judgment will be handed down in due course.